I'd like to mention item number 18, my lord.
Yes.
1818, my lord. It may kindly be taken up on February, my lord.
Why are you doing for?
My lord.
What is the reason?
My lord.
Reason
the
for
reason?
adjournment?
My lord, due to personal difficulty.
Mr. A.K. S.K.J. Council for the petition. Praise for adjournment. Personal difficulty. Prayer is adopted after
13, 14, my lord.
4 weeks. No
After
fixed
4.
date. After 4
Interim order is there.
interim order.
So victim is item number 29.
29.
29. We
Yeah.
taken after 2 weeks, madam. This indicates commercial conflict.
On request of the council for the petition, let this matter be listed after.
Custom method.
Wait, is the lordship. Lordship, a small accommodation for the item 25, my lord. Can it be taken up day after tomorrow, my lord? We are ready with the case.
Item
Yes,
number
yes, yes.
25,
25, day after tomorrow, my lord.
Mr. M.A. Chaudhary, praise for an adjournment due to personal difficulty. Prayer is allowed. Let this matter be listed on 5th of
5th of March.
Yes.
Deep your blood.
Every lottery also I victim as item number 4. But the ladder card is determined out of pressure. Meta पे पहले listed on next week.
Mr. What is your name?
As just Bahuri.
S.J. Sohriya, that the council for the petition praise for an adjournment on the ground that conducting council is out of stage. Prayer is allowed. Let this matter be listed after it.
I victim information number 12, my lord. It will come to that not due to partner.
Mr. Mr.
Admission.
What is your name?
Yes, for my
Chairman, the council for the petition who prays for an adjournment on the ground that the senior conducting council for the petition is out of the- considering the ground, the prayer is allowed. Let this matter be listed after it.
obliged.
Thank you, Justice. Documentation for listing my lord bail application for tomorrow.
When have you filed?
Today. Okay.
Wait, please, your lordship. Lordship, I'd like to mention item number 30, lordship. Probably case diary is not there, lordship.
1-3.
30, lordship. Let the matter come up next Monday, lord. Yes, lordship, not available.
Third, Mr. B. Chaudhary, for third, Mr. A.K. Parachar.
On 8.
For an additional purpose. Submit. Who prays for some more time for producing the case diary. Prayer is allowed. Let this matter be
8
listed
1
on
minute.
8th of January.
Highly obliged.
May I please, Lord? But with the consent of the other side, I documentation item number 16, Lord. Lordship, may kindly adjourn this matter for today, Lordship, as the engagement is out of date.
Lordship, I am for the petitioner. Let it come on Monday, 8th of January.
Third, Mr. M.K. Das, Senate Counsel for the petition, who prays for an adjournment. Ms. M. Das, Senate Counsel for the petitioner, also does not opposes the prayer for adjournment. Hence, the prayer is allowed. Let this matter be listed on
Monday,
after a week. No,
Only date may be fixed.
date will be fixed.
it is the admission matter. Let it come up after it. No date.
May I please, Lord? Lordship, I beg to mention for listing of a bail application, Lord, on tomorrow or day after.
Yeah.
Obliged.
Lordship, I beg to mention item 37. Highly matter be done for the day. After next week.
Third, Mr.
Or after.
R. Akhtar, Counsel for prays for the petitioner. The prayer is allowed. That
yes,
is
CD not available, my lord. That may
No
be
interim.
Then it additional public prosecutor
Better like-
also submits that some more time will be allowed to produce the case.
Nine.
file.
on 9, my lord. 9 1.
Prayer is allowed. Let this matter be listed on 9th of January.
Please, I beg to mention that item number 11 and 39 matter may be passed.
39.
Is the ground
39 CD is available. 11, my lord, admission matter. 11, no problem.
in 11 heard Miss, what is your name?
Be that
Heard Miss B. Das, counsel for petitioner, who prays for an adjournment. What is the ground?
my engaged
Oh.
counselor
Ground of personal difficulty of the engaged conducting counsel. The prayer is allowed. Let this matter be listed after it. 39 also same. order.
39, my lord, yes, my lord, next week, my lord, immediately because CD is available.
39 give a fixed date.
Yes, that may be 6, my lord. 8, 9, 9,
9th of January.
9, 9.
9th of
may I please note I cover copy this is at listed but
Well,
rule listed it was
Here at present CD is not available. We have contact our office, my lord. CD may be, my lord, because it is from Sonapur PS, my lord. So it may take my lord, due course, my lord.
Okay. Let it be called.
My lord, we have already asked our office to serve.
Yeah, please, your lordship, I would like to mention for a matter for urgent district on IA criminal 881 of it
When?
on 8 January.
It's not regular relief for the after
Lord, I beg to mention item number 42, my lord. May I prefer upgradation of the case at 2, my lord. My personal problem, my lord.
You wait. Why upgradation?
My lord, in personal difficulty, I have to leave left the court after at 2:30. my lord. At 2, my
To
At 2.
lord. Lord,
Sorry, at 2.
please, your lord. I beg to mention item number 12, your lord.
11.
I pray for password.
12 already করেছিলেন already
well,
Sorry.
somebody has mentioned
Well,
May please your lordship, I beg to mention for the listing of a bill matter at the theatre.
When?
Tomorrow or day after tomorrow.
Yeah.
Oblige you.
My future law. Right. Beg to mention for withdrawal, lordship, it has been listed today on item number 49, supplementary list. I have instruction to withdraw this petition as of now. Because the liberty
supplementary list is not item number 49.
supplementary motion.
Heard Mr. What is your name?
VA Chaudhary on behalf
Heard
of
Mr.
Mr.
B.
A.M.
A.
Bora.
Chaudhary, counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant criminal petition. Considering the submissions made by the counsel, the prayer is allowed. This criminal petition is dismissed on behalf
And the liberty may kindly be
with the liberty
filed
file
afresh
afresh
if required.
if required.
Highly obliged.
May I please your lordship. My lord, this is in transportation of the criminal case, my lord. My lord, this FIR number, my lord, 31 of 2015 of Udaipur case number, but charge sheeted, lord, on 29 to 2016, my lord, and under section 341, 392, and 34 IPC. Trial is going on, my lord. Some PWs in thief also already recorded, my lord.
Who is defending you?
No advocate is the problem. There is no lawyer in the bar is ready to.
Now, court may engage a counsel.
My lord, yes, as per section 304. But my lord, when senior lawyer is making a situation that no one should appear, a legal aid counsel may be under section 304, but this will not, my lord, complete the provision of 303. I have to have a competent lawyer of my choice, man. That is my fundamental right. And my lord, I am trying my level best for last 2-3 years, my lord. No engage, even the clerk is not writing my hajira, my lord. So, my lord, I have to file my petition myself, my lord. On 2 occasions, it is recorded also, my lord. Kindly turn to page number, my lord, 20, my lord.
My lord, that application, your lordship may kindly come to page 20. That application was filed in the year 2000, my lord, 17.
Yes.
And my lord, now out of witnesses already trial is going on, my lord.
Now who is defending you? Somebody is defending.
No, my lord. No one is there. Well, I'm coming to the point, my lord.
No, we will issue direction for to the court
Yes,
to appoint a
No,
legal.
my lord, this is my lord, this will not serve the purpose, my lord. Kindly see the, my lord, this being a senior himself lawyer, who is himself
this-
appearing.
Okay,
my
we are issuing notice.
lord, I may not be in a position to, my lord, without a competent lawyer, my lord, how can I defend myself with a person who himself is appearing and defending the being a victim and witness himself, my lord, and lawyer himself, lawyer, himself, witness himself, my lord, victim, my lord. And no case, important PWB is yet been cross-examined, denied, my lord. Kindly say the record is there, my lord. Your lordship kindly, my lord, kindly turn to page 22, my lord.
Now, how many witnesses are,
8, my lord.
how many witnesses are examined
No,
already?
5, my lord. Only chief part, not cross-examined. Kindly see the, my lord, page 22, my lord.
The cross-examination is deferred.
My lord, not done because, my lord, this Edward is not willing to do, my lord. Only it was also done under a circumstance, my lord. There was an understanding that it will be compromised, my lord, out of the court. But it is not being happened. Now totally denied, all denied to refuse to take my brief, my lord. My lord, kindly see the order, my lord, date, page 22, my lord. It is seen from the case record that PW1 Badrul and PW4 Saleh Ahmed have not been, they are the main witnesses, my lord. They are not cross-examined. And on the last occasion they came, nobody, my lord, conducted. So cost was imposed on me, 2000. And my lord, kindly then turn to page 24, my lord. 24, my lord. Beg to state that this GR case is against the petitioner and other 2 accused, namely Abdur Rahman and Rashid Ahmed. This false case was filed at an instance of Salim Ahmed under the conspiracy, who is the main witness in the connection with a past
Now, what
political.
is your grievance that you are not?
Exactly, my lord.
No, Mr. Talukdar, what is your grievance? You are not
Grievances, my
defended
lord,
by.
I am unable to represent my case engaging a competent lawyer.
Now there is no counsel.
No counsel.
No one is defending.
No one is defending. Even the clerk is not writing my Hazira.
Court has not appointed a legal aid counsel. Yes.
No, my lord, I have not prayed so because I do not want to be
No,
legally.
even if you have not prayed, whether court has appointed.
No, my lord, not appointed, not appointed.
Let us call for a report for.
Yes.
Let us, my lord.
Call for a report from the trial.
It is up to your lordship, but I think, my lord, stay may be granted past, my lord. Then, my lord.
No stay, because you have come already 5 witnesses.
Yes, correct. But kindly see the, my lord, the cross could not be done. It was not done because of the this purpose, my lord. And it was an understanding that it will be held amicably, my lord, out of the court. This is not happened. Thereafter, my lord, kindly see, my lord.
We will consider after getting a report from the trial.
Then a short date meeting.
Heard Mr. A.K. Talukdar. Also heard Mr. P. Thakur and the additional. This application of the 407 of the Court of Appeal has been filed by the petitioner, namely Moinul, namely petitioners, namely Moinul Islam,
And 2 other, my lord.
Rashid Ahmed and Abedul Rahman, praying for transferring the DR case number 207/2015 pending in the court of the chief judicial state Karimganj to any other competent court neighboring district on the ground that no lawyer of Karimganj bar is willing to represent the petitioner before the trial. Stop. The counsel for the petitioner has also submitted. Has also submitted that already 5 out of 10 witnesses were examined by the prosecution side. However, the petitioners remain undefended in trial.
And cross-examination was not done, my lord, of the
And
time witnesses.
and the witnesses who were already examined were not cross-examined.
As per my lord statement of the my lord petitioner, learned trial court has also not appointed any my lord legal aid counsel.
It is also submitted by learned counsel for petitioner that
Yes.
no legal aid counsel has been appointed by the learned
Yes,
trial court to
yes.
defend the cause of the petition. Hence, prayer for transfer has issue notice to the respondent as an additional copy procedure has appeared for respondent for one more formal notice to be as regards respondent number 2 and 3 are concerned, the petitioner shall take steps for issuance of notice and respondent within 3 days from the date of this order, returnable after 3 weeks.
My lord, the next date is fixed on 14/1. my lord.
3 weeks. You want a fixed date,
Before that, if possible. my lord.
not possible, because courts are 3 weeks. Date 20, returnable on 23rd January. Let also a report be called for from the Senate Chief Judicial Magistrate Karimganj regarding the plea made by the petitioner. This case. Fix this case again on 23rd January.
My lord, on that day, my lord, stay may be considered. Stay, my lord.
The prayer for interim
Day of the
relief,
lower court proceeding.
interim relief would be considered only after service of notice on the respondent as well as receipt of court from that chief petition. Fix the part.
Of that.
A small fair matter. So far as item number 11 is concerned, the petition has taken time, but I am for the respondent without consent of me. In
You
fact,
have not been informed.
no, my lord. Lordship, what is happened, my lord, since 2017, maintenance not paid to me, my lord, and 42 petition is pending before the honorable court. In fact, 42 is not lie against the order of the family court, my lord. In fact, last occasion, LCR is called for execution even stop due to pendency of the case and execution case recorded before the honorable court. So I'm pray for fix the first date, ma'am.
Item number
11.
after the
Date may be fixed, other matter will not come.
QAP 11
Obli-
May please, your lordship. Lordship, what is happening in this case, lordship? Lordship, kindly come to page number 66, lordship. Annexure 7, 66.
Yes.
Lordship, the petitioner, lordship, was convicted by the additional CGM in an NI case, lordship. Thereafter, he filed an appeal, lordship, in the Court of Sessions, lordship. Therefore, due to the non-staying of the appeal, lordship, non-staying of the order of the conviction, lordship, he was sent to jail. So, lordship, due to the non-staying, lordship, and due to the non-payment of his 20% of the interim compensation, that order, lordship, is on
that was directed to be
yes, lordship. The directed to be paid statutory compensation. That is on page 54, lordship. Page 54.
Yes.
That is 17/3/2023. As 16th is the appeal was admitted, lordship. 16/3/2023, and on 17th, time is allowed to the appellant to make the statutory deposit. Thereafter, lordship, he was unable to pay the statutory deposit, due to which, lordship, the additional CGM, lordship, issued a warrant of arrest lordship, against him. That is on page number lordship. Annexure 563, page 63 lordship.
Yeah.
Okay. So lordship, after on the strength of warrant of arrest lordship, he was arrested on next page lordship 64, annexure 6, 3/12/2023. He was arrested, and since then he has been in jail. My only humble submission is lordship, if the lordship appeal, just it is that order may be modified.
Appeal is pending.
Yes, appeal is pending in the court of session.
You pay that statutory amount.
Lordship, that is the problem, lordship. Actually, the amount is 24 lakh 50,000. He has to pay amount of 4 lakh. So he's unable to pay that.
Then there is no way out.
Lordship, actually, under lordship 143(5) lordship, they may lordship, as if it was a fine under 421 lordship, they may proceed under 421 of CRP. Or it may be stayed and given some time to pay lordship, so that he may be out lordship. Otherwise, he won't be able to pay that whole amount.
No, if 20% appellate court has directed you
Yes,
to
sir.
pay 20%.
Yes.
You are unable to pay.
At least some time may be granted, sir, extension of time to pay lordship. In the meantime, it may be stayed lordship. Otherwise, lordship, being inside lordship, you won't be able to pay.
Now, which order you are challenging?
We are challenging lordship the order dated 7, that is page 54-55, annexure 3 lordship. The impugn order dated 17/3/2023 lordship, and lordship the order dated annexure 7, page 66-69, that is the on the strength of WA, whereby he was arrested for.
Then your revision is barred by limitation.
But that
And
due to
Malad, there is,
which lordship he was there.
Because
And-
Some relief may be granted.
and there is no prayer for bail also.
That's right.
no, you are challenging the order 17/3/23.
Yes, sir.
This is a revision petition.
Yes,
3 months
lordship.
have
I
elapsed.
understand.
So that is barred by limitation.
That is the ongoing process, lordship. After that also, those orders, they have only taken time.
No, you have to challenge a specific.
Yes, lordship. We have challenged 2 orders, lordship. The
Next one
impugn order dated 17/3/2023, and the last order that is passed by the additional CGM,
which one?
that is 4/12/2023, whereby he is behind the bar. He is undergoing the simple imprisonment. That is on page 66.
Otherwise, my lord, they will have to mandatorily deposit 20%. Let them first deposit some amount, thereafter, my lord, make a prayer before the, my lord, learned session judge, then learned trial court may consider, my lord, his prayer.
He is the only lordship working person. He is from inside the jail, lordship, he won't be able to pay. Lordship, at least it may be stayed in 15 days time may be granted to him, or 20
Don't
days.
stay without hearing the heard Mr. D. Heard Mr.
Mr. PK.
P.K. Dar. Also heard report heard this application of 397/401 has been filed by the petition Abdul Sheikh, alias Abdul Sheikh, unique the order 73 passed by the 33/2000 as well as order dated 4/12/2000 passed by the Second Judge Kokrajhar, Criminal Appeal 5/2000. Whereby present petitioner was sent jail person to the judgment and order person to the judgment passed in NI case number 20/2020. Counted for the petitioner has paid deposit statutory deposit under the section. That statutory deposit is between
143A, Lord.
143A of the NI Act. That is counted for the that paid that sometime may be given into the petition so as to enable me to pay the statutory because as directed by the first of them. Issue notice to the notice for
Component number 2, Lord.
as an additional public prosecutor has appeared for as regard the petitioner shall take steps by registered 3 days from the order returnable on the 3rd of the prayer for interim relief shall be considered after service of notice on is not to let 23rd.
So can it not be 22nd? Right. May I please also put revision petition against conviction also. Under NI Act 138 NI Act, 1 year conviction and 30 lakhs has been sentenced as fine. Will kindly admit it and call for a record.
Third, Mr. D. Abdar, and a counsel for the state is not a party.
State formal party is there.
Also, Mr. P. Borders,
That's for number 2.
This application 401 397 of the Code of Conduct has been filed by the petitioner in the expedient form of court, impugning the judgment and order dated 10/10/2020 passed by the Session Judge Sagar in criminal appeal number 11 with the bracket 1/2016, whereby the judgment passed by the additional chief petition magistrate Sagar in CR case number NI 44/2012. What was the date of the first appeal?
Judgment order at 2/3/19. That was order passed by the additional CJI.
2/3/19 was upheld by the first appeal, whereby the present petitioner was sentenced to was convicted under section 138 of the Negotiable Instrument Act 1881 and was sentenced to undergo simple for 1 year and was also sentenced to pay a fine of 30 lakhs and in default of payment of fine undergo simple imprisonment for 6 months more. issue notice to respondent.
Number one.
Respondent number 2 is represented by an edition of no formal notice need to be issued. As regards respondent number 1 is concerned, the petitioner shall take steps for issuance of by registered post date 3 days from the order. Returnable for
IA is there.
IA. You are in jail or out?
No, after 1 year, on previous bill. I'm on previous bill. He will be allowed to remain on previous bill and the sentence and the
In
fine. that
IA,
he is
whether we have to hear the other side.
No, no, it is one, NI case, 1 year conviction, that's fine.
This interlocutory application has been filed under section 397 of the Code of Criminal Procedure by the petitioner praying for suspending the operation of impugn judgment and order dated 10/10/2023 passed by learned Sessions Judge Sagar, whereby the judgment and order dated
2/3/19.
2/3/19 passed by the additional judicial CR case number NI 44/2012 was upheld by the first appellate court. By the trial court, the present petitioner was convicted under section 138 of the Negotiable Settlement Act and was sentenced to undergo simple imprisonment for 1 year and pay a fine of 30 lakh and a cost of payment further six. The judgment of the first appellate court has been impugned by the present petitioner by filing a connected criminal revision 571/2020, which is admitted for the earlier order. Stop. Learned counsel for the petitioner has submitted that he has good ground for preparing the connected criminal revision and has chances of success that since the conviction is for a limited period of 1 year only during the pendency of the connected criminal revision. For considering the incident prayer, whether we have to hear.
No, that's not required here, because under 148 already 6 lakh was paid at the time of appeal. That was paid.
20%.
That 20% was paid here in the appeal. So now it is not necessary because already he has received the 6 lakh out of
the
the second. 20% already.
During the pendency of the criminal revision number 571/2023, the operation of impugn order is hereby stayed,
And he will be allowed to remain on previous.
and the petitioner is allowed to remain on previous date. The interlocutory application is for
Mark.
Yeah, please, your lordship. Lordship, the 482 petition, my lord. For watching of the proceedings, my lord. My lord, the cognizance has been taken against the petitioner, my lord, the 448 and 376, my lord.
376.
My lord. My lord, I'm aware that with regard to 376 is a societal, but my lord, it has to be looked upon the effect of each case in a different way, my lord, my submission. My lord, here, the case of,
Now, what is your ground for?
my ground for, my lord, is first, my lord, the FI, my lord, 4 grounds are there. First, the FI instance was of 2/11, it was on 2nd. The FI was closed on 5th. There was no medical corroboration with the contents of the FIR. Third, the respondent number 2, who is the victim, has sworn an affidavit, and the contents of those sworn contents of those affidavits were even present in the 161 statements and 164 of the trial court record matter, where she has stated that out of enmity, at that time, out of misunderstanding, she has lost the FIR. So, my lord, when the respondent number 2 is not supporting the prosecution,
Victim is saying that he has lost.
yes, my lord, I have given an affidavit that has been given by her. And when, my lord, those certified copies I cannot obtain, my lord, but has gone for the record where the victim has stated that previous enmity was there in the 161 statement. Where, my lord, my ground, one of the ground is the respondent number 2 is not supporting the prosecution story, my lord, itself. Medical is not corroborating, and the contents of the FIR, my lord, is of 2nd, and the FIR was lost on 5th, my lord. And moreover, my lord, these are my grounds, my lord, because it will finally, my lord, lead to, it will carry nothing else but chances of acquittal of the respondent, the petitioner, my lord. My lord, my main ground is the respondent number 2, which the victim is not supporting the prosecution story, my lord. They have stated that out of misunderstanding because
What
of
he has stated in 164 statement.
my lord, that certified copies are not allowed, my
He
lord.
might have
My lord,
indicated you.
yes, 164 and 164 we cannot, my lord, it is still presently also.
Okay.
161 I have read, my lord, in which he has stated that previous enmity was there.
Oh,
So,
maybe.
my lord, that is.
But even if she
164 I
indicated
cannot-
you under 164,
Well,
that is
FIR
enough.
lost on my lord 5/11/2019.
My lord,
That
uh,
may not be
Thereafter,
ground for.
Yes, charge sheet filed on my lord 31/12/2019. Thereafter, summons he was shown as absconder in the charge sheet. Summons issued, my lord.
my lord,
On 2 dates, my lord, he has not appeared before the trial court. My lord, charge not yet framed. Let him first, my lord,
yes, my
place
lord,
all these at the time of framing charge, my
yes,
lord.
my lord, with regard to it, I also like one submission of the apex court. My lord, the apex court has stated, my lord, in one of the recent judgment that if an application with, my lord, this is with regard to 376 only, we will put the judgment that I will say. My lord, in
Which
this,
judgment?
this Kapil, my lord, Kapil Gupta. My lord, may I give one?
What it?
With regard to specific, this is with regard to, my lord,
No, what it has.
my lord, it is with regard to 376 only, the same sort of allegation with a similar footing. My lord, I only take your lordship to paragraph number 13, 14, and 16 of the judgment. My lord, paragraph 13.
No, here there was an amicable settlement.
Here also, my lord, the same. The trial has not proceeded in that case also. In this case also, amicable settlement, the affidavit itself, my lord. And my lord, here, one more submission with regard to it, that is the initial stage, my lord. In that judgment of paragraph 14, it has been stated that, however, if such an application is made at an initial stage before commencement of trial, the said factor will wait with the court in exercising the power. Paragraph 14, the last second 2 lines.
That is a my lord, notarized affidavit. How can I say at this stage that was filed out of duress, out of coercion, my lord?
I am praying for.
And my lord, offense is under 376, my lord.
Number 2 notice may be issued. No, because my lord, here, one
Okay,
of
we
the,
are issuing. Our Miss SG Purva. Its application for it. Right with Article 2(7) of the Constitution has been filed, praying for washing of the charge sheet. What is the prayer?
washing of the proceedings, my lord.
Washing of the proceeding
Proceeding
of
of
PRC case number 1364/2020 under section 448/376 of the Indian Penal Code on the ground that the victim of the said case has file an affidavit be- before whom?
Before the, my lord, page 32, before the notary public at North Lakhimpur,
No, where that affidavit,
North Lakhimpur.
no, where you have submitted that,
My lord, page 32.
before which authority you have
No, my lord,
Nowhere submitted.
nowhere
First
submitted.
time
because
in
my-
this petition annex. my lord.
This first time petition, I'm praying. Because the-
affidavit that mentioning that the case against the petitioner has been wrongly has been filed due to
misunderstanding
misunderstanding
out of previous enemy.
because of previous that the counsel for the petitioner has submitted that there is every probability that if the case is proceeded against the present petitioner, it would result only in acquittal. Therefore, there is no purpose in proceeding with the case, proceeding in PRC case for not the that issue notice to the court and call for the scanned copy of case record of 3136/2023 as well as scanned copy of what is the scanned copy of the case diary of Taluk PS case number
Lalu PS case number, my lord. Lalu PS case number 399/2019.
399,000 as an additional public prosecutor has appeared for respondent number 1. No form is needed. As regard to respondent number 2 is the petitioner can take steps for it
Lord, as well as taxi, my
by registered post in 3 days from the date of the order returnable after 3. Petitioner is also allowed to take steps for it with respondent number 2 through the scheme. Let this matter be listed again after notice.
my lord, can stay of it. Because
After service of the prayer for interim relief would be considered after service of
must oblige, my lord.
May I please, Lord. The application under 482, Lord, the value section 397 of Chairman. With a prayer for quashing the proceeding in FC criminal case number 138 of 2023, pending before the learned family court below, Lord.
what is
Lordship, summary of this criminal petition,
no
Lordship,
what case it is maintenance case.
Lordship maintenance case, Lord. On the same grounds, Lordship, on same pleading, on same cause of action, another case under section 12 of the DV Act was also instituted by the
But there may be parallel case.
maybe parallel case, Lordship. I am an employee, Lordship, private employee, Lordship. Having salary rupees 9,000 only, all the documents
These
I have
grounds
furnished.
you can take before the trial court. But that whether that can be a ground for quashing the
Lordship, whereas the Lordship, the benefits of the DV Act, Lordship, there are many benefits, Lordship. Like the protection order, residence order, monetary relief, Lordship, and residence order, compensation order, Lordship. So better.
no, is
for
there
the,
any bar for
So Lordship, admitted Lordship, there is no bar, Lordship, but
then
parallel proceedings on the same cause of action on same bundle of facts, Lordship, cannot be allowed for the national justice law.
do you have any authority that DV Act and 125 cannot
No, Lordship, there is no admittedly, Lordship, there is no part, Lordship. So for section 26, Lordship, other
Then-
Lordship, other relief can be sought for, Lordship. Lordship, whereas I am a private employee in the capacity of personal assistant of the railway department, Lordship. Lordship, having salary rupees 9,000, and also I have financial burden, Lordship. So, Lordship, how is it possible to give the maintenance to the same wife, Lordship, in the two products?
This, please, you can take
Lordship, at this stage, Lordship, proceeding may kindly be stated and notice may kindly be issued, Lordship.
which one there, that's not. I'm thinking about whether to issue
Lord-
heard Mr. A.K. Ahmed, that council for the also heard. Not this application of the code, code has been filed by who is the petitioner?
Lordship, Nomita Bayon. Here in this petition, Lordship, Pranjal Dekal. Sri Pranjal Dekal.
But you have not made
Nomita Bayon has been made respondent, Lordship. Nomita Bayon is the wife of the petitioner.
petitioner Pranjal Dekar praying for watching proceedings of FC Wicked Criminal case number 138/2020 pending before the court of London, family court number 1, Guwahati, on the ground that the petitioner is that the respondent has also filed another parallel proceeding for maintenance under DB Act before the which is that case?
Lordship, Miss DV case, Lordship, of 42 of 2023.
Registered as Ms. DB case number 42 of 2020
23, Lordship.
23 pending before the court of
Judicial Magistrate, Kamru Metro, Guwahati.
judicial magistrate Kamru Metro. Issue notice which was not the petitioner can take state for registered date within 3 days from date when they put up. The
Got
this case is not up.
Much.
May I please, your lordship? This is a 482 petition, my lordship. Lordship, the FIR is page number 16, my lordship. I'm seeking quashing of the FIR. Bolton Bazar, case number 211 of 2020, registered under section 376, the IPC.
What is the ground for
Lordship, this FIR has been lodged after 2 months of the incident, my lordship, number 1. Number 2, my lordship, he is a major lady, he is an educated lady, he knows the consequences. After knowing the consequences, she herself agreed to stay in the hotel, my lord. My lordship, not only this, my lordship, when she filed the FIR, she said it is a boyfriend and girlfriend relationship, my lord. Very surprisingly, my lordship, kindly see as page number 56 of the petition, my lordship. She filed a maintenance petition, my lordship. Page number 56, my lord. My lordship got FC criminal number 421 of 2003, whereby in the first paragraph, she say, third paragraph, my lord, she said that the petitioner begged to state that the marriage between first party and second party was solemnized on 3/9/2021 as per Hindu rights. She's saying that husband and wife relationship, my lord. Even if her stories believe, my lordship, there is no 376 cases made out, my lordship. Kindly see the FIR, my lordship, as page number 16, my lordship, 16. My lordship got it? 16 page number. This is the FIR, my lordship. This is the translated version, my lord.
Notice may be issued, my
very quick?
Alright.
Mr.
D. Hussain, my lord.
E. said that the towards the product. Application for it has been filed by Deep Saha for watching the fire basis of the pleasure PSK P11 that submitted that though in the FIR it has been alleged that that when the incident occurred,
The incident happened after 2 months, my lordship. It says that is in paragraph number 3, my lord. Marriage was fixed on 26th of January. She did not attend the marriage. After shopping, after booking of the marriage, well, everything was done, my lordship. All slip, I have an extra receipt, I have annexed, my lordship. After 2 months, my lordship, she convinced me, the petitioner, to come in Guwahati. She convinced me. And we stayed 4 nights, and after 4 nights, she said,
Page 16, my lord.
page 16, my lordship.
after 2 months of 26 January.
Yes, my lord.
As per allegation, my lord, it is the my lord, petitioner who has refused. After my lord, date is fixed on 26th of January 2023.
Everything was fixed, my lord.
And thereafter, my lord, after that, my lord, incident, after 2 months, my lord, the present, my lord,
The
incident
allegation of rape is in the year 2023.
2023.
What was that
In the first paragraph, she
Offense-
herself says, I have a
offense-
love affair.
offense alleged against occurred year 2000. However, the respondent number 2
Two.
has also filed an
Subsequent in the
application
case.
under section 125 of the Code of Code, the Principal Judge Family Court, which has been registered as seeking in the criminal case court 23, wherein the respondent number 1 has also mentioned that marriage between petitioner and respondent number 1 was solemnized on 3/9/2020. Therefore, that no offense I would have
Well, case diary also may be called.
noticed on the petitioner appeared for as regards to the petitioner had taken within period of 3 days date of January after 3. That also case diary of that case gets report for
That is, my lord. Interim.
prayer for interim relief check copy of service of notice.
Highly obliged, my lord. I'm grateful.
May it please the Lord. My Lord, this is an application under section 482 CRPC. My Lord, for quashing of a charge sheet filed in the case, the FIR is at page 11, man, which shows that this is purely a case of civil nature because this is for recovery of loan amount. At page 11.
That it was made under what
406, I think.
406.
Yes. He has also served a demand notice, my lord, NHR 5 at page 23, regarding the same amount. And also he has filed another FIR at page 26, my lord, in another police station in Gwalpara district. Here it is in Guwahati. So my limited prayer is for issuance of a notice and interim prayer may be considered after 34.
Third, Mr.
NH Majarvi.
Third, Mr.
NH Majarvi.
N.H. Matarmia, Learned Counsel for Water application of the Court of filed by Petitioner Muhammad Rezaul now praying for watching the hearing here with 1917 that 2021 pending before the Court of SCJM 2 improvement. Call for the scanned copy of the case for CRC case 1917 along with scanned copy of the case diary. Athigaon PS case number 6 and each notice. That the petitioner for particular has appeared for respondent for 1, 2, 3. No formal state respondent. However, as in respondent number 4 is done, the petitioner shall take the body with on board by registered post date 3 days date of returnable of the let the prayer for the officer.
Wait, please, Your Lordship. This is an application under section 482 of the CRPC. I have challenged the charge sheet and also the order dated 6/11/2023 passed by the learned session judge Saraido, whereby cognizance of this case was taken under section 306 IPC against me. Well, the only thing that connects me to the case is a questionable suicide note. Well, in the charge sheet, the police, after investigation, they have mentioned that in spite of best efforts made by them, they could not even trace out any handwriting match of the deceased to match it with the suicide note. So under those circumstances, whether this suicide note will at all be established. Besides that, my lord, all the independent witnesses have stated in their statements recorded under 161 CRPC that the deceased was a habitual drunkard and a gambler. He had lost huge money in business. And my lord, there is no material whatsoever in during the investigation to show that there was any instigation from my end to end within the close proximity of the incident, my lord.
Yes. We do not.
My lord, I have a prayer for stay also, my lord.
What is the state?
My lord, the next state is fixed for consideration of charge.
You have appeared yet?
My lord, I have already appeared, my lord. Sessions case, my lord.
Let them make all these arguments at the time of framing charge. Well, all the date for consideration
No,
of charge is fixed. Well,
My lord, your lordship knows the Pepsi Foods Limited case, my lord.
What is
My lord, a criminal law cannot be set into motion only as a matter of course. There are no materials.
let us go through
Yes. Well, your lordship wants to go
it. No, not
the
case,
judgment, my lord.
not the judgment, but whether there are materials. on-
Yes, yes, my lord.
So we will call for the
Yes.
and copy of the case.
Yes, yes, my lord. Yes, my lord.
Our Mr.
D. Goswami.
E. Goswami, Learned Counsel for also heard for that this application today has been filed by the petitioner Hemanto Gogoi, Elias Kumar Gogoi, praying for watching the charge sheet number 81 dated 3/31/2023 filed in Moran PS case number 75/22, as well as impugning the order dated 28.
I am also challenging the order dated 6/11/2023, my lord.
Really?
Well, your lordship will find it in the prayer. Prayer is at page 15, my lord. Order dated 6/11/2023.
As well as impugning the order dated 6/11/2023 passed by the Session Judge Doraidev in section 3A case number 74/2023, whereby cognizance under section 306 of the Indian Penal Code was taken against the present petition. 306, the session tribal case.
Yes,
Cognizance is taken by the committal court, not
yes,
not
by the committal court, my lord. I made my appearance before the learned magistrate. The case was committed, then thereafter cognizance was taken.
issue notice to the respondent and call for the scanned copy of the case record of sessions case number session case number 3HJ session 3HJ case number 74/23, along with the scanned copy of the case diary of
Look here.
what is the police station case?
Yes, yes, my lord.
Moranhat police
Moranhat
station,
PS case number 75 of
75,
2022.
2020.
Lordship may fix a date, my lord.
24 June.
May I please, Your Lord? This is 438 application, registered under section 420, 406, 379, and 34 of IPC. Lordship, FIR is in page number 10. May I read, Your Lord?
Page number 10.
10.
Yes.
That the above mentioned accused person has taken my four-wheeler vehicle, that is Mahindra XUV 500 WB, being registration number so and so, from my house by way of purchase, under the condition that he will pay the remaining installment along with 1,50,000 to me within a week by executing an agreement. But since then, the accused person has never met me, and after expire of the period of time as per the agreement, I have called many times to the accused person, but he did not receive my calls. Thereby, I am on doubt that above named accused might be deceived me to theft my vehicle by executing a fake agreement, and also I am on doubt that above named accused might be use my vehicle in any illegal activity by theft my vehicle. Therefore, it is my humble prayer before the concerned authority to recover my above mentioned vehicle from the accused person as soon as possible.
There was
Lordship,
an agreement executed between the parties. Thereafter, my lord, regarding but now for difficulty is that he has not violated the terms of that agreement and not returned the vehicle. He has returned.
No, Lordship, the fact is, accused person has purchased the above stated vehicle from the informant in the month of October 2021, not 2020. And it is also a fact that the accused petitioner agrees to pay an amount of rupees 150,000 to the informant within a stipulated period of time to 2 months. And from the date of execution of the sale purchase agreement, which has already been paid within 2 months from 30 September 2021 to 12 November 2021, an amount of rupees 1,50,000 to the informant in various installments through UPI, Google Pay, from his nephew's account. That is annexure 21227, Lordship. The UPI transaction. Page number 16, Lordship. Page number 16 to
How much you have paid?
the agreement, according to the agreement, 1,50,000, we have paid 1,55,000 to him. And it was also agreed that at the time of purchasing the vehicle, between the remaining installment will be paid by the accused petitioner to the informant,
Okay.
and he
Now
will,
what is your submission?
Lordship, the actual agreement amount was 1,50,000, which has already been paid by me within 2 months from the date of execution of the agreement, and remaining the installment amounts, which is paid by me to the informant in the month of December 21, January 22, and February 22, by 20,000 per month. And after 3 months, I came to know that he was not paying the installment in the finance company. Thereafter, I started to pay the installment by myself, which are annexures 3, Lordship. And now I'm paying the installments to the finance company direct myself.
And any other submission?
No, Lordship.
The nature of allegations are, nature of dispute is of civil nature.
Yes. Otherwise, my lord, those amounts were paid in the year
That
2021.
submission is required,
Lordship.
Yes,
that the nature of dispute is
civil.
civil. Miss, what is your name?
It does not.
Miss Neda, also heard Mr. Report. This application of the Section 438 of the Court of Appeal has been filed by the petitioner Vipul Chandra Pudita, who is apprehending his arrest in connection with Jalupari PS case number 715/2020 under Section 420/06 that's the Code of the list of accusation in this case. One Pranjal Devdi, that on 7/12/2023, one Pranjal Devdi had lodged an FIR before the officer in charge of Jalupari Police Station for my inter-area for my taking that the present petitioner has taken has purchased the four-wheeler vehicle from four-wheeler vehicle, that is Mahindra XUV 500 WP, bearing registration number AN0M0786 from the informant on the condition that you pay the remaining installment along with a sum of rupees 1,50,000 the informant within a week of the exit of that agreement. However, it is alleged that even after expiry of the said period as per the agreement, the present failed to pay the agreed amount and also failed to return back the vehicle. Learned counsel for the petitioner have submitted that petitioner has already paid with 1,55,000 to the informant through UPI mode, and in support of our submission, he has referred, he has produced, he has annexed as annexure to series the copies of UPI payment, the snapshot of what are these?
Google Pay.
Snapshot of UPI payment made by the present petitioner to the informant through Google Pay. It is also submitted that the petitioner, after payment of 1,55,000 to the informant, came to know that the informant has not paid the installment to the finance company from whom the vehicle was financed, and thereafter the petitioner himself started paying the installment to the state finance. Learned counsel for the dispute between the parties are of civil nature, and the present fire has been caused to take harass. It is also submitted by the that the petitioner would cooperate in the investigation. Therefore, he may be allowed to go on with that great work. The other hand, can we
Considering,
dispose
yes,
it off?
yes, your lordship may also dispose it of
Instead of call-
considering the nature of allegation.
Learned counsel for learned petitioner for prosecutor has also submitted that the nature of allegation level in the FIR shows that dispute is predominantly civil in nature, and therefore custodial detention cannot be accepted. And considering the submissions made by learned counsel for petitioner as well as learned petitioner for prosecutor, the petitioner is hereby directed to petitioner Shri Vipul Chandra Kalita is hereby directed to appear before the
Jalupari PSK.
investigating officer of Jalupari PS case number 715/2020 within a period of 10 days from the date of this order and cooperate with it. If he does so within stipulated period of time, the stipulated period of time, in the event of his arrest in connection with Jalupari PS case number 715, the above notification can be allowed to go on bail of 30,000 150 of fine, subject to the satisfaction of the arrest authority following condition. With above observation, the next step to be application.
Much okay.
Your Lordship may peruse the last order.
This is the NCB.
Your Lordship may look into it. Last order. From quite a long time, my lord. I was arrested on 6/11/2020.
Where is Mr. KR?
My lord, I saw him in the morning today. Their names are also shown. And my lord, the trial court, my lord, the orders are PO is transferred, PO is on leave, PO is on training. Last order, my lord, the day when they appeared, PO is on leave. For quite a long time, PO is transferred, PO is on training, PO is on leave. And it is fixed for consideration of charge. 3 years, 2 months. And your Lordship has passed quite a few judgments on that, my lord. Long incarnation in the jail for no fault of mine. And my lord, another argument, my lord, your Lordship, that concept of section 50, my lord, I can place it from the record, my lord, that was not at all, because imperative in the condition of by the prosecution that if along with the vehicle and the other goods.
Now, what would be, how would it be,
My lord,
regarding hearing the,
My lord, what to do, my lord? My lord, last time also they taken time. Every time they are taking time, my lord. And now today they are not appearing. Last occasion, your lordship has passed an order that no indulgence will be given to them. And he is in the court, my lord. I've seen him today morning, man.
I am trying to inform he has not received the call. So, Your Lordship may kindly taken after some time.
okay, we'll take it up after.
My lord, my lord, but if they again
Let
take,
us take it up at 2.
my lord, but if they again want to take time, my lord, then it will,
Let us see what.
they will definitely ask for time.
May please. Is 439 application. The petitioner is behind the bar since 27/12/2020, just a little bit above 1 year.
27,
12/2020. Your Lordship, what has happened? The FIR, Your Lordship, is the base debt.
This is NDPS.
NDPS case, it's a commercial quantity. The amount recovered is 300 grams of heroin. And Your Lordship, my first point is at page 12, if Your Lordship will kindly take up the page 12 is the original FIR. Here, I'll just read the FIR. I have the honor to state that on 26/12/2022, which is December, at around 5 p.m., source information was received that one Alto bearing registration number so-and-so was being used by one drug peddler for transporting and supplying narcotics in Pathan Bazar, PS, and other areas of Guwahati. Accordingly, the input was developed and the car and the supplier were apprehended on 26/12/2022 at 9 p.m. Your Lordship, time is very important. Near Excel Care Hospital on the highway bypass. The peddler was taken to his rented flat near Tetelia, Sarial, and search was carried out in the presence of witnesses. During charge, 22 numbers of soap boxes containing heroin were traced and seized. The heroin weighed 300 grams without cover, in addition to 53,000 in cash, which was the income of the accused from selling narcotics. 200 numbers of empty vials used for selling drugs and 202 number plates bearing so-and-so were traced and seized. It is found that the accused, as detailed below, has been carrying on business selling narcotics in Pathan Bazar area. Your Lordship, this is basically FIR. There are two things, Your Lordship. First is that the information was received at 5 p.m. The person was apprehended on the same day at 9 p.m. Then he was taken to his rented flat, and there the search was carried out. That is obviously after 9. Now, Your Lordship will kindly go to the seizure list. Seizure memo. I'll just show one thing in the seizure memo. That is at page 18, 1/8. Handwritten one, I'm typed one, I'm not. It's in English. Here, Your Lordship will see date and time of seizure 26/12/2022 at 9 p.m. Then Your Lordship will find place from where seized, rented flat of accused person. So these are basically two things. Now, Your Lordship will kindly turn to page 20. This is the order of the learned magistrate. Page 20, or the order of the magistrate. Here I am trying to show one thing, Your Lordship, about the sampling part. Page 21 is the relevant part. Order on drawing of sampling. We'll see serial number 1313. The seized narcotic, drug, psychotropic substance, controlled substance, as produced before me and mixed together in a plain paper, wherein the weight is 282 grams. So it is, they have said, of 5 grams each is drawn from the entire homogeneous mixture, and the residual amount of so and so gram, the samples are marked as SDR. Now, the IO is directed to send the representative samples to the FSM. Now, what has happened, dear Lord? 3 samples were drawn. The samples were directed. Next, page 22, directions to IO. Page 22, 18. IO is directed to send the samples collected to the concerned investigating authority within the statutory period. Now, what has happened, your lordship? The IO has sent the samples, but he did not send the whole sample. Just one sample was ultimately sent. That your lordship will get at page 33. There should have been 3 packets under the seal envelope, but only 1 packet was sent. So page 33 is the report of the forensic forensic officer. Here your lordship will see the description of articles. In fact, before that, your lordship, mode in which parcel found to be packed on receipt of description of seal. The parcel consisted of 1 exhibit enclosed in a seal envelope cover. The facsimile of the seal was found to be election Assam. Now a description of the art. 1 seal envelope marked exhibit A, MR so having a closed polythene packet containing 5 gram light brown color substance. Result, your lordship, it is positive test for heroin. The percentage is 72.6. I have nothing to see. There were 3 packets where your lordship sees. 1 was set. There was a direction by the court to send all the 3 samples. Only 1 was set. That is 1. Now your lordship will kindly take, I have filed a additional affidavit. I'll come to my law point later. First, I'm just trying to point out the relevant facts. I have filed an additional affidavit.
Where is that?
That is filed on 10/11/23. Lordship has got the.
It is in the file, my lord. Backside of the briefing.
আমি তো কেটে ফেলি।
After the Wakalatnama, there is in the main file.
In the additional affidavit, Lord will kindly go to para 9. There were 11 witnesses in total. Out of 11, 3 witnesses have already given their deposition. So I'm just trying to point out what was the evidence of these 3 witnesses. Very short depositions. This is a page 39 in continuity and 9 in the affidavit. This is the PW1, if your lordship has got that page. PW1, your lordship. I will read the deposition of the PW1 that your lordship, on both part I am not reading, your lordship. Second part, your lordship will just turn to page 40, that is internal page 10. I'll just read. I did not know the person in whose house the search was conducted. These are Caesar, sorry, yes, your lordship. These are Caesar witnesses. I'm just pointing it. I did not know the person in whose house the search was conducted. Police did not interrogate me. They only took my signature. I signed the Caesar list as asked by the police. This is important. I do not know exactly what was seized. This is important. I do not remember the date of the incident. Fine. Now again, I do not know the quantity of the contraband seized. This is another important point. It is not a fact that I was not present at the time of search. It is not a fact that no drugs were seized from the house. Now last one. It is a fact that the drugs were not weighed in my presence. So these 3 points does not prove anything, your lordship, with regard to the seize. Now your lordship will kindly turn to the next page, 41, internal 10, PW2. Again, I'll turn to page 42. Next page.
No, what point you are trying?
I am trying to come to, first I will come to 40 of the NDPS Act, that I will come. Then this is with regard to the evidence of witnesses, which does not prove anything here. That the
Out of 11 witnesses, how many?
three witnesses, all these 3 are, your lordship, Caesar witnesses. Now, Caesar witnesses, your lordship, I'm not into the trial. Obviously, it will be in the trial, whether this will be proved or not. But from the evidences that has come up before your lordship, can a person be convicted under this type of evidences? Thus, I'm trying to point out, just, I think 3 lines or 4 lines they have given. Page 42. See, both, all the three, or just kindly see how they are going to prove whether these are correct procedure has been done or not. I have not seen from where the soap boxes were recovered. On being asked by police, I put my signature on the seizure list. The recovered drugs were not weighed in my presence. I cannot say whether the recovered items were drugs or other substances. The drugs were recovered from the upper floor, but I cannot say from which room it was recovered. After recovery of the drugs, this is very important. After recovery of the drugs, I was called by the police. What kind of a seizure witness you got? Rest, it is not affected. The rest I'm not reading. Then third, PW3. These are the only 3 witnesses, your independent witnesses in the whole case. Here also, your lordship, page 43, last part. I signed the seizure list as asked by police.
Out of 11, how many witnesses were examined? till
Three.
now?
These are the only 3 examined till date.
So,
And
there-
all these 3 witnesses are seizure witnesses, independent seizure witnesses. And all the 3 witnesses, what is the, your lordship, the evidence given by them? Whether this type of evidence will
But-
ever,
8 witnesses are remaining.
8 witnesses are still remaining. More, all are, I think, all these 8 witnesses are official.
They may implicate.
Yes, they may implicate, but your lordship, seizure part. If I go into the seizure part, this cannot be the procedure which is adopted. Because a seizure, a witness
Now,
cannot be
whether-
called after the seizure.
Whether at the time of considering bail,
No, this is one point. I'll come to the other. Right? That is, no, if your lordship feels, why I'm trying to point out this, because there is my whole issue was, if a person who is ultimately going to be, cannot be convicted on the basis of this type of a seizure procedure, is he entitled to bail for his, whether he's have to be there before before in the jail for a long period of time, wherein ultimately he's not going to be convicted on the basis of this type of evidences. This is what I'm trying to point out. Just one angle of my basic argument here. Just bear with me for a moment. That's it. I'll just read 43 also, your lordship. This is why I'm saying. I signed the seizure list asked by the police. I do not know the content of the seizure list. I do not know from whom the powdery substances were recovered. I do not know from which room of the building the powdery substance were recovered. I was not present at the time of search. So under these conditions, your lordship, the Honorable Supreme Court has already said, these are, your lordship, procedure absolutely illegal. So that part, your lordship, just pointing it out in such a situation, whether a person is entitled to bail. Now, your lordship, I'll come to the second part, which I'm arguing, that is where I am shown, your lordship, at 9 p.m. The person was arrested in the highway. He was taken to his rented house, where in this rented house, from the evidence, I can point out that from the evidence, it seems that it is a house where there are many rooms. In one room, this person stays. So even the persons do not know from which room the substances were recovered. It was not recovered from the person concerned in the car. He was taken to the room where he stays in the rented house. From the house, a search was conducted. That is after 9 p.m. So directly violation of section 40 of the NTP. Now, your lordship, on that ground, I'm not reading further. I'll just give your lordship 3 judgments. Just these 3 judgments. Main parties bail or not is a different aspect. That is your lordship's prerogative. But the question is, this is the type of, your lordship, the whole process goes into, and ultimately after a period of 3, 4, 5 years, nothing happens. So I'm trying to point out. Your lordship will kindly take up the Supreme Court judgment in the state of Rajasthan versus Jagraj Singh Hans. That is 2016. 3 judgments are there. Just 2 are Supreme Court, 1 is from the Bombay High Court. I'll just first and foremost, I'm trying to point out the case of Rajasthan versus Jagraj Singh Hans. Here, your lordship will kindly turn to
again
42. This is 42.
But after full trial.
This is after full trial, but I'm trying to I'll come to that bail part in the last judgment. So I'm trying to show whether 42 is mandatory or not. So your lordship will kindly take up page 4, para 11. Page 4, para 11. I'll not read the whole one. Page 4, para 11. This is the section 42. If your lordship wants me to read this, then it has been quoted here in this case. Page 11, page 4, para 11. This is the present case, section 42 is relevant, which is extracted below. So here it is, section 42 has been extracted, and in the next page, or in the last line, your lordship, the act is kept or concealed in any building, conveyance or enclosed place may between sunrise and sun. So this is my first line of argument. It should be between sunrise and sun. So in December, after 9 p.m., it cannot be sunrise or sunset. So it will be after sunset, before sun. So this is the first violation of Article 42 of the of NDPS Act. Now your lordship will kindly turn.
No, which is the last?
That para 11 you have got your lordship. Para 11 I'm not reading. This is the quoting the section 42 of NDPS Act. So if your lordship will turn to the next page. I'm not reading the whole section 42. So the next page, your lordship will kindly come down the last line of that paragraph itself. Section 42, first paragraph.
D, 42D.
No, sorry. If your lordship, 42 itself. 42 starts from page 4.
Yes.
In the page 5, that first paragraph in the top.
Okay.
Then here your lordship, psychosis or controlled substance in respect of act has been committed, or any document or other article which may furnish evidence of the commission of such offense.
In between sunrise and
between sun. Here your lordship, it is between sunrise, not between sunrise and sunset. It is after sunrise, before sunset. So this is the violation. Why I'm coming to that? Then your lordship will kindly turn to next the page 6, para 14. Another aspect of non-compliance of section 42(1) proviso, which has been found by the High Court, needs to be avoided. Section 42(1) indicates that any authorized officer can carry on out search between sunrise and sunset without warrant or authorization. The scheme indicates that in the event the search has to be made between sunset and sunrise, a warrant would be necessary unless officer has reasons to believe that a search warrant or authorization cannot be obtained without affording the opportunity of escape of the offender, which ground of his belief has to be recorded. Now here, your lordship, one proviso is that if the offender is going to run away, then it is not. Here the question is different totally, because he was earlier arrested, then taken to the house. There is no question of running away. So that part doesn't come. So here the authorization is required, arrest warrant is required. Authorization is required for search and seizure. Without that, you cannot do between sunset and sunset. This was done here without following the procedure of 40.
Without that, can be done provided you mention the reason.
The reasons, yes. There is no reason. There is no reason. Yes, the reasons has to be shown, and the belief is there that the person will run away. Here the question, that question doesn't arise.
Now, whether reasons are there or not.
No, that is not. According to my argument, lordship, he will be in a better position to show if there are reasons. Then your lordship, I'll just come to the last page 9. Page 9. The 9 is, your lordship will find the pagination down below. Page 9, there is a paragraph 20. After referring large number of cases, this court recorded conclusion in paragraph 25, which is to the following effect. The question considered arise frequently before the trial court. Therefore, we find it necessary to set our conclusions, which are as follows. I will not read the first and 1, 2A, 2B. I will come to your lordship 2C. That is at the next page. Under section 42(1), the empowered officer, if has a prior information given by any person that should be necessary, be taken down in writing, But if he has reason to believe from personal knowledge that offences under section have been committed or materials which have furnished evidence of commission of such offences concealed in any building, he may carry out arrest of such without a warrant between sunrise and sunset. And this provision does not mandate that he should record his reasons of belief. But under the provision of section, if an officer has to carry out such search between sunset and sunrise, he must record the grounds of his belief. The second part, to this extent, these provisions are mandatory and contravention of the same would affect the prosecution case and vitiate the trial. I'll not read further. So here, this part is mandatory. If he has given reasons why he has done so, I do not have the case. But if he does not give the reason, then your lordship, it will vitiate the trial. Once your lordship knows that the trial would be vitiated under these conditions, whether the person is entitled to pay. Now, next part, your lord, next case is a case of Bhutta Singh versus State of Haryana. This is a recent judgment, 2021 SSC Online 324. I have given the SSC Online at the top. Here, your lordship, I'll just read two paragraphs. Paragraph 10. I'll not read the whole paragraph because this is the in paragraph 10, the constitutional bench judgment is quoted in this case. This is the Colonel Singh's judgment where it was held by the constitutional bench that 42 is mandatory. So I'll not read again the same thing repeated. Now in para 29, that is at page 10, your lordship, the court has come to the following argument. Just page 10, para 20. Just I'll read this back. After referring to the earlier judgment, the Constitution bench came to conclusion that non-compliance with requirements of Section 42 and 50 is impermissible, whereas delayed compliance with satisfactory explanation will be acceptable compliance with Section 42. The Constitutional bench noted the effect of the aforesaid two decisions in para 5. The present is not a case where insofar compliance with Section 42 provides even an argument based on substantial compliance is raised. There is total non-compliance with Section 42(1) proviso. As observed above, this is with regard to 43 not being attractive. Search was to be conducted after complying with the provisions of Section 42. Thus, we conclude that High Court has rightly held that non-compliance of Section 42(1) and 2 were proved on the record, and the High Court has not committed any error in setting aside the condition. I'll not read the further part. Now, last judgment, your lordship, this is on the bail part. That is Sivraj Gorakh Satpute versus State of Maharashtra. This is by Bombay High Court. Anyway, I'll just read your lordship two paragraphs. Paragraph 7. Why I'm trying to point out that these are fatal to ultimately the case which leads to bail. Para 7 at page 4 out of 10. This is a bail application. The applicant seeks bail inter alia on the ground of breach of Section 42 of NDPS. The provision deals with the power of entry, search, seizure, and arrest without warrant or authorization. The scope of Section 42 has been considered by the Apex Court in the state of Rajasthan versus Jagraj Singh Hansa that I have already shown your lordship. That is 2016 11 SCC 6787. I have not given the SCC, but this is SCC. Then Bhutta Singh, the earlier one, your lordship, 2021 SCC Online SC32. The Apex Court has observed that Section 42(1) indicates that any authorized officer can carry out search between sunrise and sunset without warrant or authorization. The scheme indicates that in the event of search has been made between sunrise and sunset, the warrant would be necessary unless the officer has reasons to believe that a search warrant or authorization cannot be obtained without affording opportunity to the offender to escape, and the grounds of belief have to be recorded. This was the specific ground for bail in that case, your lord. Ultimately, your lordship, at para 9, page 6, this is the factual part of the case. Para 9, page 6. In the instead case, it is not a dispute that the house of the applicant was searched and Gaza was seized between sunset and sunrise without any warrant or authorization, and that there was no compliance on Section 42 of the NDPS. This is the only part here of the argument that I am pointing before you. Then ultimately, your lordship, in the last part of that paragraph, in next page, the concerned officer has not recorded reasons for such belief in terms of proviso of Section 42(1) of the NDPS Act. Hence, prima facie, the search and seizure, which is in contravention of the mandatory provisions of section 42 of the NDPS Act, prima facie makes the recovery. So under that circumstances, this learned court has, honorable court has given bail relief. So this is the reason, Your Lordship, I have pointed out that yes, these facts and Your Lordship evidences are also a part of the record which is before Your Lordship, and Lordship can always take a note of that. Whether under these circumstances, which is correct procedure has been done or not. If it is not done, then obviously Your Lordship, it is a trial factor is different. The trial matter ultimately the court says that no, he's entitled to acquittal. So under such circumstances, whether the person is entitled, he is obviously going to face the trial. That is not, but bail is the initial part. Just because faulty, Your Lordship, faulty investigation cannot keep a person behind the bar for
No,
so
no,
long.
my query is, suppose 42 is not followed.
Yeah.
There is contravention of
Yeah.
40, which if it appears from record that there
Yeah.
is, then whether the condition mentioned in section 37
Yeah.
that for granting bail you have to arrive at a reasonable satisfaction that you are not guilty.
Yeah.
That satisfaction can be arrived at
Yeah.
only because of the fact that it is not.
That is what, yes,
Because-
exactly, Your Lordship, is the correct question. When 37 is guilty or not will be in the trial. Normally it's in the trial, whether person, but when the trial is defective, when the investigation is defective and ultimate result of the trial is not going to be, it is more, in all probability, is going to be in the favor of the accused, then Your Lordship, is it necessary to keep the accused behind the bar till the trial is over, or whether he is entitled to bail so that he can participate in the trial, and then ultimately whatever happens in the trial is a part.
No, I have understood you. My query is there, do you have any authority where it is specifically mentioned because of the non-compliance of 40 second proviso? The petitioner is entitled to get paid because that satisfaction can be arrived at.
Yeah.
That is not because of the non.
That specific judgment I did not pick not today, but
But
the
is there
Bombay
any-
High Court on that fact and figure.
Bombay High Court has said, but it is not so many words. It has not.
No, it has not indicated 37.
37
37 it has not.
My query is
Whether that is
37
also.
hurdle is there. I have to jump 37.
So 37, if Your Lordship desire, I have to get authority on it. That I can try to, I'll get it by tomorrow.
Or otherwise, in this case, Mr. Parat,
My lord,
is there non-compliance of 42?
my lord, regarding 42, one aspect is there, my
Because
lord, yes,
the search is made at night
yes, definitely.
inside a house.
House.
So whether 42,
Not only regarding escape, but concealment of evidence also there, my lord. That
reasons have to be made.
reasons have to be, but reasons
If
recorded are
reasons
not.
are not there,
That,
then
that,
42 is not complied.
yes, but
If
my
there
lord,
is non-compliance of 42, whether 37 can be jumped
No,
over.
That part,
That you will
that
show-
I'll
that aspect also I'll look into, my lord. Regarding, my lord, here, my lord, lower court record, my lord, LCR, my lord, LCR only up to 8/11/23, there is a report that till then, no.
no,
Subsequently,
three witness. We have filed here.
subsequently that additional affidavit came, my lord, 3 witness examined out of 11. The 8 more go. And
No,
that
the case
aspect,
there you will find out
yes, that aspect, my lord, I have actually not checked, my lord, regarding that aspect, my lord. Only I have,
whether
check-
there is compliance of 42. or-
yes,
That-
subsequent immediate to the senior officer, it is, my lord,
Before
result
entering into how, whether reasons are recorded in
Recorded.
writing,
writing.
that for this reason, I have to conduct search
Yes.
during night.
Any note of
Only
the
small requirement, whether that was, all-
it's
you go through that and you come up with a decision.
I'll get,
decision
I'll get.
because of no-
I remember, but I do not have.
I also think that there are judgments.
Yes,
but
I
to show
remember,
that-
but I am not, I do not have it with me now.
Show those judgments.
Yes, yes.
When will you
Friday,
heard Mr. Y. S. Khanna, Learned Counsel for the petitioner, also at K.K. Parak, Learned petitioner, Learned Counsel for the petitioner, as well as petitioner of sought some more time for answering the queries posed by the court regarding non-compliance of section 40. Where the let it
Right.
right 5 months.
Nacho.
I'm taking a short break. It is there. No, you are always trying. This is an NDPS case.
In this is LCR come lordship.
21C is there.
LCR come.
What is to be done? Otherwise, you don't have a case. Okay. Heard Mr. R. Akhtar, Learned Counsel for the petitioner, who raised for an adjournment on account of practical difficulty of the conducting counsel. It appears from record that on last 3 occasions, petitioner has consecutively taken adjournments on one or other ground. However, considering the ground mentioned by the petitioner today, prayer is allowed. Let this matter be listed.
On 11th of this month lordship. Because lordship, it will be
After
too long.
After 2.
After 2. That
No.
may be fixed. Otherwise, again, it will not reach lordship.
Oh.
LCR is there.
On 23rd, let this matter be fixed on 23rd.
As a last chance lordship. Otherwise,
No
petition-
further indulgence shall be granted to the petitioner.
for you. Yeah, I think LCR.
May I please go back? I'm appearing as a legal aid counsel, my lord. 439 application.
May kindly peruse the last order. Not the last, the previous.
Status of trial.
And the lordship, there is a call, also lordship has called for the FSL report, another thing, but that has not been received. CD is not here, lordship. Only few witnesses has come, but CD has not received.
Otherwise, it is a case involving commercial quantity of. What is it?
My lord, where from the state tempo was not belong to me, my lord. And I was just traveling as a passenger, my lord. I have not taken as a rent. It was a misunderstanding of police. Nothing recovered from me, my lord. I was just a
For that lordship, CD is required lordship, because CD from the city lordship, we can see lordship whether how it is seized.
Now it is pending for trial or investigation is going.
Trial for trial. Investigation is going, trial is going on.
Charge sheet has been laid again.
Lordship.
2 years completed, my lord, already.
2 years.
2 years. 31/12/21 because there is 2 years already completed. Just may kindly allow me on.
And what is the stage of?
As per the status report, lordship, 4 witnesses has been examined, lordship, and but only 3 witnesses statements are there, lordship, and
Hello, I will face the trial, my lord. My lord, may kindly allow me on bail. I will clear.
Where is the status report?
first page, I think it is in the first page.
My main point is, my lord, ganja was recovered from the temple, my lord, not from me.
No, you are on merit or you are on the ground that you have been detained for long. Because on both ground you may get, if on merit you can show that. So if you are on long detention, that then you have to make specific submission that these are the case law. Because 2 years is a long. How much ganja was it?
20.96.
So by 0.9 kgs you are exceeding. 20.9 kg. So 900 grams were more. 20 kg is the commercial quantity. Yes.
CD, Lordship, may kindly call for the CD because CD is not available, so we cannot go through, we cannot say anything what is, how she will argue, on what point she will argue. I cannot defend the statement. CD is required in the
Can copy of the case diary.
case they required. Enter
Heard Miss M. Das, learned legal aid counsel for the petitioner. Also heard Mr. P. S. Lawford, learned additional public prosecutor, who submits that though the scanned copy of the case record of special NDPS case number 1/2022 is there. However, considering the submissions made by learned counsel for the petitioner, perusal of the case diary of Laluk PS case number 434/2021 would be necessary for considering of the for consideration of the instant bail application. Before that, before that, the learned counsel for the petitioner has submitted that the present petitioner was only a passenger in the auto rickshaw from where from where contraband was seized, and it was not seized from his possession. It is also submitted by learned counsel, learned legal aid counsel, that the petitioner was arrested on 31/1/2020,
31/12/2020.
31/12/2021, and already 2 years.
31 of 2 years.
And already more than 2 years have been completed, and the trial is proceeding at a slow pace, and only 4 witnesses have been examined. Out of each of them. So, considering the submissions made by learned counsel for the petitioner, as well as learned additional public prosecutor, perusal of the case diary would also be necessary for consideration of instant bail application. Hence, call for the case diary or scan copy.
Scan copy of the case and
Call for the scan copy of the case diary of Laluk PS case number
434.
434/21, along with an up-to-date status report of the special NDPS case number 1 of the 22 pending before the Court of Learned Additional Session Judge within bracket FTC Lakhimpur. The registry shall take steps for requisitioning the aforesaid scan copy. Let this matter be listed after
24/1.
Let this matter be listed on 24/1.
Like.
This is the lordship. And 439 application, and these petitioners are behind the bar for last 729 days. Brother. They were arrested on 5/1/2022, and they are facing trial, my lord, under the NDPS Act. And in this matter, my lord, they have already completed 729 days as on today.
What was his?
It was the ganja, my lord. They are the truck driver and the helper, my lord, both of them. Petition number 1 was the truck driver, my lord, and 2 was the helper of the truck, and they were intercepted during a Naka checking, my lord.
How much ganja was it?
300 kgs were recovered, my lord. And 6 witnesses, my lord, examined in this matter. Out of 11, my lord, out of 11 witnesses, listed witnesses. My limited suspicion is that, my lord, considering the length of detention, my lord, they are for conditional release, may be considered, my lord, with stringent condition. my lord.
But if I look into the evidences, Lordship, there are 6 witnesses are there, and 5 of them are independent witnesses. All of them have implicated him. Lordship. So metals are there. Evidence are there. Moreover, the trial is also going on regular basis.
My lord, first,
Next date fixed for 17/1/24.
my lord, it was, FIR was blocked.
When the last witness was examined?
Last witness was examined November, my lord. I have annexed that page, PW6, page 51 of my petition, my lord. First day of November 2020. 51 page of my petition, my lord.
And when the charges were framed?
Charges are framed on 9/6.
9/6/2022, charge fair date.
22.
Yes, my lord. And my lord, first prosecution witness was examined on
No, that is not necessary.
Otherwise, the independent witnesses implicated, Lordship. And informant is still now not, deposition has not been taken, Lordship.
informant is a police person, my lord.
So, Lordship. So other independent witnesses also implicated.
No, he is not on merit.
Not.
He is on long incarceration.
Section 37 is there, Lord.
My lord, if I may place your lordship, very recent bail order, my lord, where lordship has picked up all the recent judgments of Supreme Court and others, my lord, where incarceration was considered for a conditional basis. Paragraph 12, one was lordship has cited all the, my lord, judgments passed by the Honorable Supreme Court, my lord, specifically the Ravi Prakash, my lord, at paragraph 12.
Yes. So,
Lordship, the prima facie it is established, Lordship, as per section 37.
Sorry.
729 days comes to how many in years?
It's, my lord, 1 year, 11 months, 29 days, man. 2 days short of probably 2 years or what? 1 year, 11th month, 29 days.
The next date is fixed on
17/1.
17.
how many witnesses were?
11,
11 are there.
witnesses are there, madam. And 6 in this long period, madam, only 6 has been examined. They also not regular, madam, after madam, 2 months or 3 months, regular interval, one by one they are appearing. So, madam, conditional, in any stringent condition, if they are paid, can be considered, madam.
No, on 14 it is fixed.
17/1.
Let us see how many witnesses on 17th.
Madam.
Suppose no witness is examined on 17th, then we may consider. Remaining witness may be, because 5 witnesses may be examine on a single lane. It's not difficult in NDPS case.
But my humble submission is that only, my lord. Balance has to be meted out, my lord. One side society has to be taken into consider, lord. And on the other hand, the accused has to be, rights has to be considered, lord.
No, but there is a period within which you have to complete the
Lord,
trial. Otherwise,
That itself recognized
But
by the
you-
Act, my lord.
conditional liberty, they are entitled to.
Lordship, I understood that, but as per section 37, Lordship, prima facie it has to be established. And if you look into the independent witnesses, and moreover, informant has not been till now not examined, Lord.
Okay. Third, Mr. M.A. M.A. Chaudhary, Learned Counsel for the petitioner, also heard Mr. K.K. Karaj. K.K. Das, Learned Additional Purpose. Learned Counsel for the petitioner has submitted that petitioner. How many petitioners are there?
2 petitioners are there, my lord.
The petitioners who are the
Driver.
driver and the helper of the vehicle from which 300 kgs of ganja was seized are detained behind the bar since detained behind the bar for last 729 days. That is about 1 year, 11 months,
29 days.
29 days. And Learned Counsel for the petitioner has prayed for bail only on the ground of mainly on the ground of long custody. On the other hand, Learned Additional Public Prosecutor has submitted that since large quantity of ganja has been recovered in the state, a balance has been made between the right of the accused as well as the interest of the society. And he also submits that the next date of the case before the trial court is fixed on 17
1 20
17 1 20 23 and
24.
24, and therefore there is a possibility that some witnesses may also be examined on that day. Considering the submissions made by the counsel for the petitioner as well as the additional public prosecutor, and considering the fact that 6 out of 11 witnesses have already been examined, let this case be listed after 17.
24, my lord.
Ah.
Status report will be required. I'll also take instruction, my lord. If any witness is examined, I'll file certified copies of that.
After the next date fixed before the trial court, so as to let this court know as to whether any further witnesses have been examined in the case pending against the petitioner. Accordingly, let this case be listed on 24th of February 2020. Who will inform us?
My lord, I'll take instruction from the conducting
Please.
council, my lord. The conducting council for
Status
their
report may be called.
In the meanwhile,
raise
a
the-
up-to-date status report may be called for after 17
1
2020 from the 24 from the Learned trial court. Let this case be listed.
keep here.
My lord, 31 and 32 is out of the same.
Same, my lord. CD available, my lord. Same. Yes,
31, my lord,
We are taking up 31 first.
my lord.
allegation is under section 379, my lord. LS articles, my lord, were recovered on the first day itself, my lord, on the day of arrest. Today is 50 days behind the bar, my lord. Lordship may
What
kindly
was
con-
the article?
my lord. Those were, my lord, some mobile tower articles, my lord. As per a FIR, only one, this was, my lord, one RRU unit, my lord, of mobile remote radio unit, RRU unit, my lord. Page 7 is the FIR, my lord. And my lord, police have recovered 23 numbers of RR unit, my lord. As per FIR, the informant alleged that one unit was stolen, and the police has recovered 23 numbers of RR used, my lord.
What is the name of the petitioner?
My lord, petitioner's name, my lord, is
Javed.
Malik. Our
From his possession,
yes, 23, my lord. We take it as scrap and we sell it, my lord. We take it to Delhi, my lord. We are not the thief, my lord, selling all this, my lord. These are all, my lord, not in working condition. As per police, my lord, this has stolen. Whatever, my lord, will face trial. 50 days, my lord, today, my lord. Only 10 days left for state trial.
Yes, Malat, he in his statement also confessed that some person Malat gave him, and he Malat supposed to stole earlier also Malat around 6,000, 5,000 per unit Malat.
Yes,
Baseband unit, remote radio unit, and BBK Malat baseband unit Malat.
Yes. And they have recovered some laptops, 6 numbers of laptops, and my lord, 5 numbers of tower battery, 11 number of circuits, my lord. All, my lord, not in working condition. These are all, my lord, scrap, my lord.
laptops are also scrap.
All scrap. These are sold in 2,000 rupees per laptop.
What is the progress of it?
Investigation Malat substantially progress Malat several.
You have covered these stolen articles.
Yes,
You have
yes, Malat.
heard Mr. F. Khan,
50 days.
learned counsel for the petitioner, also heard Mr. K. K. Parashar, petitioner.
They are doing it within only on length of detention Malat. They are
This
doing
application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Muhammad Javed Malik, who has been detained behind the bar since 14/11/2023 within bracket for last 50 days in
Yeah,
connection with
49.
Nunma TPS case number 319/23 under section 379 of Indian Penal. The gist of accusation against the present petitioner that on which date FIR was lodged?
My lord, FIR was lodged, my lord, on
13/11.
13/11/23.
On 13/11/23, one Pankaj Kumar of Soyuk Telematic lodged an FIR before the officer in charge of Nunmati police station, Inter area, alleging that one RRU of
Airtel Tower.
Tower, approximate value rupees 1 lakh only within bracket, has been stolen from the work jurisdiction of the first informant, that is from Gitanagar BG Road. Learned counsel for the petitioner has submitted that the petitioner deals with scrap material and the articles seized from his possession were all scrap. And learned counsel for the petitioner also submits that petitioner has already been detained behind the bar for last 50 days, and considering the period of detention, he may be allowed to go on bail. On the other hand, an additional public prosecutor has produced the case diary of Nunmati PS case number 319/2020 and has submitted that the stolen article has already been recovered. It is also submitted that the statement of the petitioner has also been recorded under section 161 of the Act. I have considered it sufficient after both sections and peruse the materials of the court, including the case diary. Considering the fact of seizure of articles alleged to have been stolen, as well as considering the period of detention already undergone by the present petitioner and progress made in the investigation, further custodial detention of the present petitioner does not appear to be necessary for fair completion of the investigation of Nunma TPS case number 319. Hence, stop. In view of above, the petitioner, namely Muhammad Javed Malik, is thereby allowed to go on bail of 30,000 with 150 of bank account, subject to the satisfaction of learned petition with following. One, will not intimidate it. With this, with above, the instant bail application is with above observation, bail application is thereby disposed. And 32.
My lord, 32 is Muhammad Monser Ali, arrested on 15/11 and total detention, my lord, 49 days. This
49 days.
Same affair.
Same affair, matlab
same
he-
allegation, same affair.
matlab he is the earlier one, the scrap owner Javed. He is matlab bringing those items and supply to Javed. He is helping.
Rag picker. He is
Matlab
a collector.
he is the collector.
He collect.
Theft are maybe some other person. Matlab. He bring those items and supply to Javed.
What is your submission?
Yes, same, my allegations are same, my lord, on both, my lord. So, my lord, only difference is, my lord, earlier he was
The
Javed was
affair is same affair.
same.
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 Same order, my lord, only date of arrest will change, my lord. Earlier was 14, this is 15, my lord.
15 matlab.
And my
Not
lord,
next.
earlier was 50 days, this is 49 days. And
Only
petitioner's
make
name
those
will change, my lord. This is it.
petitioner name will be
Muhammad Monser Ali.
Monster.
Muhammad Mancher. Date of arrest 15, 14,
15, my lord.
Here is 15.
15,
11/23.
15, 11. Period of detention is 49 days.
49 days.
Remaining same 30,000.
I am grateful, my lord.
This is your lordship. The 439 bail application, 31 days behind the bar, lordship. In this case, what has happened, lordship, one Abdul Latif has filed an FIR against the driver of his vehicle regarding non-supply of 500 cement bags, lordship. I am not the FIR name accused. I am a owner of a small hardware shop, lordship. 31 days already behind the bar, and here only 411 will be attracted to me, lord. And maximum punishment is 3 years, lordship. I am a simple shopkeeper, lordship. I am not involved with this case, lord.
Where is the affair?
FIR is at page 12, lordship. Can I go through it? Sir, most respectfully, it is
No, not necessary.
Lord.
The allegation is theft of
Cement bag.
cement bags,
cement bag.
and that has been recovered
And you are the owner
No.
from
of a hardware shop.
where the cement bag were
Not
Not all, my lord.
not all recovered, lord.
some.
Some, lord. 31 days already behind the bar.
My lord, main accused, my lord, told
The driver.
driver 380 bags of my lord, cement given to this person, my lord. And he in his statement said that my lord, as the he is not the owner, my lord, he is the caretaker of that shop, my lord, hardware shop. As his owner is not paying his my lord, salary, so he took my lord, 380 bags on at the rate of my lord, 83,000.
You are the owner or
No, actually, the shop is
More, yes,
Oh,
he is a
partnership.
partnership shop.
partner.
And he malot take those malot 380 bags and sold it at a higher price. And
I have made payment.
you purchased or you sold?
No,
he
no.
purchased from the driver
Okay. And
380 bag and sell
how many bags were recovered from his possession?
malot only Ustura,
Golab,
less than 15. That's almost he has sold malot. So
their statements are recorded.
yes, statement recorded. Malot.
Lordship, here in the forwarding report is there, Lordship, 122 bags.
122.
Page 19, if I'm not mistaken.
Out of 300 bags.
380 bags.
Total allegation was of 500 bags.
500 bags, but 130 were recovered with that truck near Bandar-Water.
380 bags were found missing.
Heard Mr. P. Bordole, Senate Council for also heard Mr. K. Paraja, petitioner for the application for the Court of 1973 has been filed by the petitioner, namely Shri Gulab Godwa, who has been detained behind the bar since 4/12/2023 within bracket for last 31 days in connection with Vipuria PS case number 207/2023. The gist of accusation against him in this case that one Abdul Safi, on 1st of December 2023, lodged an FIR for the officer in charge of Bandar Deva Police Outpost, inter area, alleging that the owner of truck bearing registration number 801 NC 9041 had sent about 500 cement bags from Dalmia Cement Factory, Lanka to Nirjuli, Arunachal Pradesh for effecting delivery of goods, state goods within a stipulated period of time. However, on 30/11/2023, the aforesaid vehicle was found parked near Bandar-Deva toll gate, and only 140 bags of cement were recovered from the said truck, and it is alleged that who is Raju Panika? It is alleged that the driver of the said vehicle, namely Raju Panika, had stole 360 bags of the cement which was loaded in the said truck. Learned counsel for the petitioner is owner of a small hardware shop, and he had purchased. You purchased?
Lord, as per the report,
No, what is your submission?
my submission is that Raju Panika has stated my name, and on the basis of his statement, I was arrested.
Okay, but what is your submission? Whether you have purchased or not, any submission you want? No submission. That he has been arrested only on the, no, or you are denying that you have not purchased. You must have a stand. Some allegations are made against you. What is your stand?
My statement, I am a simple shopkeeper. And Raju Panika, on the basis of the statement of Raju Panika, I have been arrested.
No, but you don't know on whose statement you have been arrested. You only know the allegations leveled against you.
Lord.
Some 122 bags of cement were recovered from your possession.
Lord.
Well-
Because affidavit has been filed by his sister, Lord. As per sister statement, I have.
No, I just want to know. These 122 bags are your own bag, or you have purchased it from the co-accused?
That part I have not stated. In the forwarding, it has been reflected that 120 bags has been recovered from it.
Submitted that the present has been arrested on the basis of the statement made by the co-accused. It is also submitted by the present petitioner has been detained behind the bar for last 31 days, and on the ground of detention, long detention, he may be allowed. On the other hand, learned additional public prosecutor has produced the case diary of Vipuria PS case number 207/2023 and has submitted that the main accused, that is the driver of the vehicle from driver of the vehicle, has implicated the present petitioner. It is also submitted by learned counsel for learned additional public prosecutor that 122 bags of the cement were seized from the possession of the present,
And others he sold out, my lord.
and other remaining cement bags were already sold out by the. However, it is also submitted that in the meanwhile, the investigating officer had already recorded the statement of present petitioner and other, and the investigation has also failed. So, considering the period of detention already undergone by present petitioner, as well as the progress made in the investigation, further custodial detention of the above named petitioner does not appear to be necessary for fair completion of the investigation of Vipuria PS case number 207/2023. Hence, stop. In view of above, the above named petitioner is hereby allowed to go on paid of right to the satisfaction of the Chief Judicial Magistrate, Lakhimpur, North Lakhimpur, with following with above observation.
Obliged, Your Honor. It was called for, my lord. I'm behind the bar since my last 28 days, my lord.
Did he not yet receive, my lord?
Kindly say page 12, my lord. The informant, my lord, tried to the my lord, cover up as civil to clear, my lord, criminal offense, my lord. Page 12, my lord.
CD would be required. What is the allegation?
Allegation is that I have not executed the sale deed, my lord. Even if I have executed, my lord, one agreement for sale, my lord, for selling of a particular plot of land, my lord, and the informant said that, my lord, that he has paid a substantial amount, my lord, but he has not paid full amount, my lord. And instead of going to the civil court, my lord, he has filed this, my lord.
When can you?
My lord, Sadhgam, my lord, Monday, my lord, definitely. my lord.
Friday, my lord.
Friday, my lord.
Today is not 28 days.
Friday, my lord. Definitely, Friday.
Heard Mr. S. Ford learned counsel for the petitioner. Heard Mr. K.K. Parachar, learned additional public prosecutor, who prays for some more time for producing the case. That prayer is allowed. Let this matter be decided again on 5th of January for case. None appears for the petitioner on call. On the result of the case record, it appears that the petitioner has not been represented on last many occasions when this case was called up for hearing. It appears that the petitioner is not interested in prosecuting this anticipatory bail application. Hence, this anticipatory bail application hereby dismissed and interim bail granted to the petitioner is also vacant.
35, my lord, FR, my lord.
None appears for the petitioner on call. On the other hand, an additional public prosecutor submits that in the meanwhile, the investigating officer has laid the final report in this case.
File number, my lord, 26,
Bearing
FR number 26/23, dated 31/1/23. Wrong date.
Considering the fact that final report has been late, this anticipatory bail application has become infructuous and accordingly disposed of on becoming infructuous.
This case, my product practice has been submitted. Petitioners are on interim.
मतलब maybe chicken मतलब Friday, Friday, Friday मतलब in the meantime.
Third, Mr. S. Das, Learned Counsel for also Mr. K. K. Parashar, Learned Petitioner for praise for fixing this case
नहीं गम पा
on 5th of January so that he can obtain necessary instructions as to whether charge sheet has been laid in the case of the prayer is allowed. Let this case be listed on 5th of January. Interim order shall continue till next.
Highly open.
38 मतलब 38 मतलब
Charge sheet
38 number मतलब 120/23 dated 28/9/23 against all the three petitions.
you cooperated during investigation.
Yes. Yeah.
Third, Ms.
Yeah.
T. Rajpa, Learned Counsel for the petitioner. Also, at Mr. K. K. Parashar, Learned Additional Public Prosecutor, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid and bearing charge sheet number
120/23 dated 28/9/23.
stop. Learned Counsel for the petitioner has submitted that by order dated 15/9/2023, the petitioners were granted interim anticipatory bail by this court. And as per direction of this court, the petitioners have cooperated in the investigation. Stop. Considering the submissions made by the counsel for petitioner that the petitioners have cooperated in the investigation, the interim anticipatory bail granted to the petitioners, namely Rashidul Islam, alias Shahidul Haq, number 2, Jahangir alias Muqsidul Momin, and number 3, Azmul Haq, granted by this court by order dated 15/9/2023, is hereby made absolute with condition number 2 and 3 attached to the said order remaining intact. With above observation, this
Forty also मतलब charge submitted.
Parcel submitted, Rochip.
appear before trial.
Till then, my I may be protected.
No fear is there. Third, Mr. G. Chamua, Learned Counsel for the petitioner. Also, at Mr. K. K. Parashar, Learned Additional Public, who submits that though the case diary was called for, however, in the meanwhile, charge sheet has been laid bearing charge sheet number
90/23 dated 13/12/23.
stop. In view of the fact of laying out the charge sheet, this anticipatory bail application is disposed of with an observation that the petitioner may approach the learned trial court and may seek appropriate relief before learned trial.
Apply.
Here मतलब 3 not testing.
Lordship, that price also has been held by the landed court, but due to not getting anticipatory bail, he is not unable to appear before the High Court. It's the owner of the vehicle.
Sonapur मतलब short that malat 8 on 8 malat.
Okay, one more chance.
On 8 Monday.
Third, Miss S.
Let-
Devi, Senate Counsel for the petition. Also heard Mr. K.K. Parachar, Senate petitioner, who prays for one more chance to the prosecution side for producing the case that the prayer is allowed. Let this case be listed again on 8th of January for case.
Still, my lord, 145 proceeding, my lord, attachment order has been challenged, and one interim order is also there. So nobody appears for the petitioner.
Notice to be done. After 1 week. Third, none appears for the petitioner for Senate. Mr. D. Das, Senate petitioner public prosecutor appears for the state respondent. Let this matter be listed after. it.
Make this your lordship, let a mechanical password for time being.
Sir, in this case, what I found, my lord, notice has not been served on private respondent. Notice is returned unserved, I think, because I found the envelope is there.
What case is? No, service is complete or correct. No, the notice has been refused.
Registered by registered post,
It was
there.
refused by the
Then
after some.
Right, lord.
DJ petition reference 483 CRPC. So, talking of PI case number. Talking of 61 of 2021 under section 123, 420, 182, 547, 56. Like my lord, petitioner, he was a practicing advocate in the Pakistan report. Actually, on the day of one day, the Monajit, one his client Monjit Roy has asked him to write an FIR that his mother was died as a result of accident caused by the one Utpal Katuria by driving a motorcycle. And simply he has written the FIR as per instruction of his client Monjit Roy. And on the basis of that FIR, which is in the base thing, this thing, my lord, the police of Bhaskar Burma PS has registered as Burma PS case number 82 of 2021 under section 279-304 IPC against the driver of the vehicle. And the investigation is done by one of the SI of the output. According to the investigation, the FIR was the one SI has found that the petitioner has said that the informant given in statement to him that he has not stated the vehicle number that is mentioned in the FIR. The advocate has mentioned. He said statement like, and the day after the said SI has submitted under an FIR, which is at page 16, stating that the present petitioner and the Monjit Roy and Utpal Thakuria by entering into conspiracy to deprive their to obtain compensation money from the insurance company has written this FIR, my lord. And accordingly, he has registered under case the page 10, my lord. Page 16 of the FIR. Page 16, my lord. The page 16. That is his FIR is that FIR I'm using the translated portion for the
Most respectfully, most respectfully, I beg to state that on 30/7/2021, one Sri Manjit Roy, resident of place Dalikata, he has participated to his lodge and FIR at Burma Police Station stating that on 6/3/2021, his mother, namely Jaya Roy, was knocked down when she was standing at west side of the Burma overbridge by a rider who was riding the vehicle bearing registration number 25P6814 in a very high speed and negligent manner coming from Guwahati side. Although the informant mother was admitted in the hospital, she succumbed to the injury on 17/3/2021. Thereafter, a case was registered being Burma PS case number 82 of 2021 under section 279/2004, and that is the case number registered on the basis of the FIR filed by Montessori method. During investigation, next very important, during investigation, the owner of the vehicle bearing registration number 6814 Utpal Thakuria stated that on the aforesaid day, he and the driver were traveling from Vijaynagar to Jarikata Lane on his motorcycle bearing number 25P6814. While coming to the Burma overbridge at National Highway, the driver fell off from the motorcycle and sustained reverse injury, and as a result of which she succumbed to her injury. But during investigation, it was learned that aforesaid vehicle was not visited by Utpal Thakuria during the accident, but his brother, Commander Thakuria, was riding the aforesaid motorcycle. The dead driver came along with the Commander Thakuria to Patala, and the unfortunate incident occurred during that time. As because the Commander Thakuria did not have the driving license, with him, Utpal Thakuria made false statements, and during the accident, he was driving. That is, he belonged to the Commander Thakuria, but he is by Utpal Thakuria. License is in the name of the Commander. Utpal Thakuria has no license. Statement. In the meantime, the owner of the vehicle, Utpal Thakuria, and informant Monty Joy confessed that he lodged the FIR on the advice of Advocate Gopal Talukdar, and Advocate Gopal Talukdar was also present in the police station at the time of FIR. Therefore, it is seen that the accused person named Monty Joy Utpal Thakuria and Advocate Gulab Thakuria connected concocted the aforesaid source to get the insurance money by misrepresenting the facts or circumstances of the case. Therefore, it is requested before the court to register the case. The case model, the present petitioner, Gopal Talukdar, he has simply written the FIR. Even if it false statement given, it is given by Utpal Thakuria. That is license is in the name of his brother Somoento, and he has driven the vehicle. So
the petitioner is Gopal Talukdar is the petitioner.
My lord?
Yes, he is the advocate.
Gopal Talukdar is
Gopal
the
Gopal Talukdar is the petitioner. He simply written the FIR as per request of the Monty Joy, my lord. So what is harm on his part? He being an advocate, at the request of the client, he has written the FIR. If any false statement is given by Utpal Thakuria, that it very good belong to his brother, then how he is made responsible, my lord. So the unnecessary he has dragged to this case, my lord, is the advocate. So we are filing this petition for copying the FIR against him, my lord. Actual writing of the FIR, he has not done anything, and what instruction has been given to him by Monjit Thakuria, he has written the FIR, my lord. Without any malice or criminal intention on his part, my lord. So he is unnecessary dragged to this case, and the case was registered as HCC for
no, apart from the fact, any other submission?
At 2 p.m.
Okay, we'll continue. At 2, we will continue.
Thank you. $20 or $120, and there is no chance of any conviction against any accused. So to that effect, I am bringing one case from our High Court, 2011 5 DLT. 2011 5 GLP, my lord. The going on branch. The criminal procedure codes petition section 4 is the crossing of the past information before section 120B 405 409 465 161 500 of IPC. Lodged maliciously as a counter blast to the FIR lodged by the petitioner against the respondent to ingredients and any offense found or prima facie available against the petitioner. Allegation just containing strong or like criminal conspiracy, here also this, the criminal conspiracy, forgery, etc., without any basis or materials.
In your case, what is the stage now? Charge sheet has been laid. Charge sheet has been laid.
Submitted, my lord. Under upon this, my lord, the petitioner, the informant himself is the investigator. The informant has filed the FIR and he has investigated the case, my lord. So the without any basis of materials offense of ultimate conviction being FIR cause to prevent abuse of the process of the court. So there is no sense of conviction. He has written the FIR only, and he is the advocate, practicing advocate, 14 years completed. He has an advocate, madam. There is no blemish in his practice career, madam. So the request of the client, he has written it, madam. So the FIR without and linked the cost to prevent the abuse of the process of the code, para 17, 19, and 20.
Paragraph number?
Paragraph I'll come. Paragraph is 17, 19, and 20. I'll come. Next, my lord, first information report posting principal stresses. Authority discussed. It is para 13 and 16, my lord. Para 13. My lord, as regard the causing of the FIR, law is well settled. By now, the principles of law laid down settled by the apex court in Bhajanlal case, Supra, which is followed till now, is to be applied in the present case. In the said case, it has been held that inherent power under section 482 can be exercised in certain categories of case to prevent the abuse of the process of the court. Any court or to secure the ends of justice, and they are as follows. Where the allegation made in the first information report, order complaint, and even if they are taken at their face value and accepted in the entity, do not prima facie constitute any offense or make out a case against the accused. B, where the allegation in the first information report and the other materials, if any, accompanying this FIR do not disclose the cognizable offense justifying an investigation by the police officer under section 156(1) of the code, except under an order of the magistrate without the purview of the section 155(2) of the code. C, where the uncontroverted allegations made in the FIR or complainant and the evidence collected in support of the same do not disclose the commission of any offense and make out any case against the accused. Where the allegation made in the FIR or the complainant are so absurd and inherent, improbable, on the basis of which no prudent person can even reach a just conclusion that there is sufficient grounds for proceeding against the accused. G, where it is a maliciously instituted with an ulterior motive for weakening vigilance on the accused and with a view to spite him due to private and personal grudge. 14. The FIR or the complainant must primarily disclose cognizance often justifying the investigation by the police officer, section 156(1) of the CRPC, except an order of the magistrate within the purview of section 1, where such offense has been disclosed against the petitioner is to be verified and ascertained from the FIR in question of laws by respond number 2. Now the para 15 is that in the above allegations are examined carefully, any prudent man would be able to understand that no ingredients of offense under section 120B, 406, 409, 405, 464, 182, 5 are found present or prima facie appears available against the petitioner. So some strong words of the criminal conspiracy against the state about fabrications of the suppressions of the materials, evidence, criminal use of trust, misappropriation of property, property fraud while attempting to create a liberal and the defamations on the character and this and business dealing have been used in the FIR without any basis and materials. Such use of strong words in the FIR would not by themselves justifying proceeding against the accused person unless they have any bearing the wrongdoings on this of the accused affecting the offense as defined under the IPC. And these are the guidelines given by the Supreme Court in Bhaganlal case, which is the leading case of the Supreme Court still prevail today on the basis of that. Then in a subsequent decision has been passed. There must be a prima facie case. There must be a sums of subsidy. There is no prima facie case against the accused. He has written the FIR. At the instructions of the Monjit Roy. Monjit Roy's statement was recorded. At that time, he stated, "I have not given the number." But how exactly? If the Monjit Roy has given the wrong information, then he will be liable to punishment. Why advocate mention a very good number wrong divider? So under section he himself is the first case logged by the Monjit Roy. That SI has investigated and submitted charge sheet. And secondly, he has submitted the FIR against the petitioner and the informant. And he has investigated the case. So entire thing has been manipulated by him, my lord. So if that is so, the advocate cannot practice in the court if they are unnecessarily dragged to the prosecutions by the police officer, my lord. So his 14 years service he has completed without any blemish in his career, my lord. Fairly senior man. So my humble submission that there is no prima facie case against the accused. Entire allegation is false. If any false statement is given, it is given by Monjit Roy and Utpal Thakuria. He is no way involved, my lord. And considering that the further proceeding was stayed, my lord, until further order by your lordship, my lord, in this case. Considering the nature of the case and PLF date was granted, my lord. So the prima facie, there is no scope for proceedings in this case. So proceedings may kindly be paused against the present petitioner, my lord. This is my humble submission.
Well, regarding that investigation carried out by the informant himself, that is perhaps not correct. Well, I beg to draw your lordship's attention to page 17. Page 17 of the petition. Here, informant is Mir Jahan Hussain. Page 17.
Yes.
Down below your lordship, informant's name, Mir Jahan Hussain. He logged the FIR. Then, my lord, page 29. Page 29, charge sheet starts. Your lordship may come to page 36. That is the last page of that charge sheet.
Yes.
Down below, left-hand side, date of dispatch, investigation officer, full name, Gagan Sharma.
Earlier case he was investigated. I forgot my earlier case. He has investigated and lost the FIR.
So that is not correct, madam.
Yes,
So there is no irregularity or illegality regarding investigation. Number one. Number two, my lord. It is a settled law. If there is prima facie case, then no quashing. My lord, I have seen the, my lord, statements of witnesses which categorically stated that only with a view to, my lord, taking the benefit of MST case, my lord, this was done. And this was done on the advice of this petitioner. There are categorical statements under section 161. Even, my lord, victims, my lord, cousin brother has also stated like that, my lord. So, my lord, with all respect, I submit, charge is yet to be framed. Let him argue all these points before the learned trial court. My lord, this is not a fit case for quashing, my lord. And my lord, every day we are coming across such type of cases. So far, MSCG cases are concerned, my lord. Always false, my lord. Insurance corporations, money is public money, my lord. With logic.
Manipulated by the SI, not by the public, not by the informant or not by any witness. But the insurance money may be lost because of the insurance company that afforded to lost by FIR, my lord. It will be done by because the insurance company is not a party and they have no loss in FIR. How police can take an advantage that yes, insurance money will be lost? Who has authorized them to do it, my lord?
It is the
The entire case, he has investigated the first case and thereafter he has lost the FIR. So he may not be investigated by in the same police station, same police officer has the manipulated. The case may be proceed against the informant or the other case. But how do it will proceed against the advocate? That he has written the FIR. Because of that, he will be penalized, my lord.
No, but allegation is that he suggested that wrong name.
That is their version, my lord. There is no question of his suggestion. Generally, advocate make any beef at the advice of the client, my lord. They never make any beef at his own. That the ultimately NSD case may not come to you, then how he will apprehend that it will come to me, I'll get this share of the money, my lord. It may not be that is. So the generally advocates are doing as per instructions of the client, my lord. So as per instruction, he has intended. If he has any conspiracy against the Utpal Thakuria, my lord, who will drive the FIR?
Now, whether to quash or not, we
My
have to whether to quash the proceeding or not. We have to see the materials as it is.
These are not materials for causing or that is to proceed the case against my lord.
Okay.
If your lordship do not cross, then the matter may be admitted to take further hearing, my lord.
No, 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 there is stay order.
Stay right here.
I think there is a stay order. Either way, it may be decided. It's pending from.
Stay right here.
Okay, I am reserving it.
Further
Heard
proceeding was stayed.
Heard Mr. K. Sharma, learned counsel for the petitioner. Also heard Mr. D. Das, learned additional public prosecutor. Hearing concluded, judgment reserved.
Polish.
Itu that's taken করি
Lordship, after something.
My lord, let me start, my lord. This is
Lordship,
every
Mr.
time I
there.
cannot, my lord. This is not the way, my lord. Every time, my lord. Every time.
Lordship, my
He
senior
was
came here at 2. Lordship,
You have
he was
waited for 3
waiting.
years. Wait for some time.
my lord again, my lord. By the time he will come, my lord, again there will be no time. From morning onwards, I am waiting, my lord, for this case.
Lordship, my senior has gone to court number 21. He was
Let
there
him
waiting
come.
for this case.
I'm waiting.
Lordship, same prayer, Lordship. How long, Lordship?
After that.
Lordship, what happened before vacation? They have stated that today they will do the matter.
Same
Lordship, I am
Mr.
not
P. K.
very
Roy
important,
Chaudhary is.
adjournment.
Same.
Let him come.
He has speaks at 2, Lordship, I think.
Lordship, he was there, Lordship. At 2.
Okay. You have also waited. You are how many days behind the bar?
About 4 years.
Okay. So wait for some more time, at least, Mr. Kyle come.
May I please, your lordship? My lord, 438 application, my lord. FIR at base 15. For the FIR, it is alleged that the driver and handyman in a magic vehicle, my lord, 5 numbers of cattle were carrying from Garigao, Vidyanagar near Masjid to Garigao, Vidya Field. And at that time, they were carrying the vehicle, my lord. They were carrying the cattle in a vehicle in off-site, my lord, in a wrong side, my lord. There, then the police stopped their vehicle and asked for the valid documents, my lord. And they failed to submit the valid documents of the kettle, and then they have been arrested. The handyman and driver of the vehicle were arrested and produced before the learned magistrate. And on the same day, they were released on bail, my lord. My lord, these kettle.
Who are you?
My lord, I am the, so far as per the allegation, my lord, I am the owner, purchaser of the kettle, my lord.
Kettles.
I am the purchaser of the kettle, and it is true, my lord. Because, my lord, we are the businessmen, my lord. We purchase some weak cattle, my lord, from the village. And then we feed them well and make them healthy, my lord. And we sell them and get some rupees as benefit. And we are running my family, my lord. My lord, these cattle were purchased from the village, my lord, from my own village. Therefore, my lord, there is no any market receipt, my lord. Only for maintain formalities, my lord, that is not a valid document, but a money receipt from the owner of the vehicle was taken, my lord. Just a white money receipt was taken. Otherwise, there is no any market receipt, my lord. Then the police did not admit those money receipt and apprehended my driver and handyman. And now they are after me, my lord. We are apprehending of arrest, my lord. And section is section 379 and 411, my lord. And section 11 subclause 1A of Prevention of Cruelty of Animal Act, my lord. The punishment is ₹10 only, my lord. Section 11 subclause 1A of Prevention of Cruelty to Animals Act, the punishment is only ₹10, and subsequently it is extended to ₹50. There is no punishment. Physical punishment is not there, my lord. We have not stolen the cattle, just we are carrying, and those cattle were purchased from the village, my lord. They are also my relative, my lord. Therefore, there is no valid documents except money receipt.
Yes.
Otherwise, my lord,
The
these
money
two
receipt is
persons,
also there, my
the driver and handyman,
They were arrested and released.
arrested, my lord, and they have named this person, and they also admitted themselves, lordship.
Right.
Their cows are there, but I have not found any document that is also mentioned, lordship.
My lord,
Let
money
him
receipt to him.
Lordship. Otherwise, my lord, I'll leave it to lordship.
Heard Mr. A.K. Azad, learned counsel for the petitioner. Also heard Mr. A.K. Das, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioners namely Noor Hussain and Shahjahan Ali, alias Maju, alias Soka, who are apprehending their arrest in connection with Jalukbari PS case number 699/2023 under section 379/411/34 of the Indian Penal Code, read with section 11 within bracket 1 within bracket small a of the Prevention of Cruelty Act, Cruelty to Animals Act 1960. The gist of accusation in this case is that on 27/11/2023, one Bidyut Kumar Thakuria had lodged an FIR inter alia alleging that the accused persons named in the FIR, namely Ijjat Ali and Farooq Ali, were carrying 6 numbers of cattle in a magic vehicle bearing registration number AS01NC8983 and were unable to produce any documents relating to the said cattle. It was also alleged that the cattle were carried in the said vehicle in a cruel manner. Stop. You are not named in the FIR.
My lord, directly not named, my lord. But in the forwarding report, my name has been pronounced by the co-accused.
Stop. The learned counsel for the petitioner has submitted that the the accused persons named in the FIR were the driver and the helper of the vehicle in which the kettles were being carried. And it is also submitted that both the driver and the helper were arrested, and during interrogation they have disclosed that the kettle where your name is there.
My name is in the forwarding report, my lord, page number 16, my lord.
What is your name?
Page number 15, my lord. Kindly see page number 15. In the FIR, it is also in the body of the FIR is there, my lord. In the middle para, my lord. Page number 15. The accomplice crime are known as Mazo, alias Soka and Horubabu. These are the nickname are mentioned.
Oh, you're okay. In the FIR that the present petitioners are also involved in the illegal smuggling of the kettles. Stop. Learned counsel for the petitioner has submitted that the petitioners are small businessmen and they used to purchase weak kettles, and thereafter, after feeding them, they used to sell the said kettles. It is submitted by learned counsel for the petitioner that the petitioner is the owner of all the seized kettles, and they have purchased the said kettles from the villagers of which village?
Of the same village, Garigaon.
Of Garigaon village. However, as the same were purchased from the villagers, only
money receipt was issued.
Only money receipt were given to them by the said sellers. Learned counsel for the petitioner has also submitted that the petitioner is ready to cooperate in the investigation. On the other hand, learned additional public prosecutor has produced the case diary of Jalukbari PS case number 699/2023 and has submitted that the driver and helper of the truck of the vehicle, of the seized vehicle who were arrested are already released on bail. However, they have implicated the present petitioners. Custodial detention?
Lordship, I cannot stay.
Okay. Stop. I have considered the submissions made by learned counsel for the petitioners as well as learned additional public prosecutor and have perused the case diary, perused the materials on record, including the case diary produced by the learned additional public prosecutor. Though the names of the present petitioners are implicated by the co-accused who were arrested in this case, however, it appears that the vehicle as well as kettles involved in this case are already seized, and the IO has already recorded the statement of the witnesses who were statement of the accused persons who were already arrested, and they have already been enlarged on bail. Considering the facts and circumstances, of this case, it appears that custodial detention of the present petitioners may not be necessary if they otherwise cooperate in the investigation. In view of above, both the petitioners, namely Noor Hussain alias Haru Babu and Shahjahan Ali alias Maju alias Soka, are hereby directed to appear before the investigating officer of Jalukbari PS case number 699/2023 within a period of 10 days from the date of this order. Stop. If from the date of this order and cooperate in investigation. If they do so within the stipulated period of time, comma, in the event of their arrest, they shall be allowed to go on bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and condition number 2.
Highly obliged.
May it please your lordship. My lord, 439 application.
20, item number 20.
21 is a criminal petition. Item 20. May it please your lordship. My
20.
lord, is a 439 application arrested on 6/11/2020.
How many petitioners are there?
2 months.
What? Who are they? Names?
Name, my lord. One is Sushil Prasad Shahu, and another is Dhanikalal Prasad, alias Papu.
Dhanika Lal. When they were arrested?
6/11/2020.
Both of them.
Both of them.
How many
My lord,
days have lapsed?
my lord, 3 years, 2 months around. 6/1/24 will be 2 months complete. 6 years, 3 years, 2 months. 6/1/2024 it will be complete. 2 months.
Okay.
My lord. My lord, offense report submitted. My lord, I take your lordship to one aspect of the matter at page 18, the Caesar list. Your lordship has got it?
Yes.
My lord, second column, your lordship will find, other than the recovery that was made, methamphetamine tablets from the accused, from Dhanika Lal's house and Sushil Kumar Shahu. Sushil Kumar Shahu was also searched by his body, and from his body it was recovered 5,760 rupees. My lord, from the whole charge sheet or the offense report that has been submitted, they have stated about 67 and other sections. But as regards 50, they are absolutely silent. My lord, in one of the direct case, my lord, 2018, 9/18.
No. What has been recovered from body?
Body rupees amount.
Only money.
Money. My lord, similar case, my lord, 2018 9 SCC, Supreme Court has said it is imperative on the prosecution if goods were recovered from vehicle and from polythene pack also. If they search the body and found some currency also, 50 has to be given. The legal right has to be offered to the person. If it is not done, the seizure is banned. My lord, I will place the judgment also. And now, my lord,
But no contraband was found from your
his
body.
body, it is shown 5,750. In the Supreme Court case, it was 2,500 rupees. In Supreme Court case, it was recovered was, in NDPS case, it was recovered 2,500 rupees. And 50 was given to him. And that was the law laid down in Supreme Court, while it had said, my lord, according to section 51, an employed officer should necessarily inform suspect about his legal rights if he so requires to be searched in presence of a gazetted officer or a magistrate. Strict compliance with section 51 by the employed officer is mandatory. However, applies only in case of a search of a person. Herein, PWT conducted search of bag of appellant as well as of appellant's trouser. Therefore, search conducted by PW2 was not only of bag while the appellant was carrying, but also appellant's person. Since the search of person of appellant was also involved, section 50 would be attracted herein. With the bag, he was searched, and 2,500 rupees was recovered. And so 50 has to be given to him, opportunity has to be given. And Constitution Bench has always said, your lordship is well aware of, I will place those judgment, where 50, if it is not given, then the seizure itself is bad. It goes to the root. It's void ab initio. My lord, I will place those Constitution judgment, my lord. And this is 2008.
No, seizure is bad even if the contraband is not found in
My
the
lord,
body.
here in this case it is given, my lord.
No. There, what I understand.
From the
when-
bag it was recovered.
No, when you are going to search a person,
My lord.
then irrespective of what is found
In his bag or vehicle.
you have to give a notice.
Notice or opportunity, legal right
Yes,
that has there,
that-
he has to
that
be
you are-
informed.
You may be searched by a magistrate in presence of
In front of a magistrate or a
magistrate.
gazetted officer.
If that is not followed,
Then it is bad.
then but suppose nothing was found in his body.
Body, if
Then-
it cash is, then also if he had in this case, cash was recovered, only
So
2,500.
if suppose no contraband is found in his body,
Then also, my lord,
then-
because the body was searched, along with the bag which contains the contraband. The moment you search the body, then the 50 has to come. The moment, because I will, 2018 9 SCC, page 708.
no, I have understood. But suppose 50 is not followed in that case,
My lord,
then
seizure is bad.
seizure of contraband is also bad.
Bad, my lord, but this is judgment.
Show me.
My lord.
Read out. 50 may be required, but suppose contraband is found elsewhere, not in your body.
Here in this case, contraband was recovered in the polythene bag, and body, when it was searched, 2,500 was recovered. So body from body, nothing was recovered. In the moment it is polythene bag on the street, 43 will come. But the moment he was searched in the body, if something is found other than the polythene bag, 50 has to be given to him. That is the judgment part. If I have not understood wrongly. Here, my lord, your lordship, the paragraph is para 21. Para 21. As evidence by exhibit 3, the first option was given to the appellant. My lord, the para 20 I will start. The question which arises before us, whether 51 was required to be complied with when charas was recovered only from the bag of the appellant and no charas was found on his person. Further, if first question is answered in the affirmative, whether the requirement of section 50 was strictly complied with by PW2 and PWD4, PW. As evidenced by exhibit 3, a first option was given to the appellant. PW2 was informed that it was his legal right to be searched either in the presence of a magistrate or in the presence of a gazetted officer. The appellant then asked to give his opinion by indicating whether he wanted to be searched by a magistrate or a gazetted officer. The appellant indicated that he wanted the search to be carried out in the presence of a gazetted officer. When PW4 arrived, he was introduced to the detainee as a gazetted officer, as evidenced by exhibit 4. PW4 then gave the appellant a second option. He inquired of him again whether he wanted to search in presence of a gazetted officer or in presence of a magistrate. The appellant reiterated his desire to be searched in presence of a gazetted officer. Before the search of the appellant commenced, the gazetted officer asked the appellant whether he wanted to be searched by PW2 before his own search was carried out by PW2. The appellant agreed to search PW2 before the latter carried out his search. On conducting the search, only personal belongings of PW2 was found by the appellant. On the search of the appellant in the presence of the gazetted officer, a biscuit jute bag was recovered from the appellant and rupees 2,400 cash in a denomination of 24 notes of 100 each was found in the left pocket of the appellant's trouser when the bag was opened. So here on in the polythene bag, it was charas. And when the body was searched, 2,400. And the option of 50 was given to him. He has to be told, or in writing or in told, that whether you in front of a gazetted officer or by the, and if it is not done by the Supreme Court has said.
In that case, what happened?
My lord?
In that case, then what happened?
But because here it was given, the option was given. Here it is not that the option was not given. What I want to place is, my lord, if the body is searched, then this has to be given. Here in this case, option was given to him. Whether you want to be, that is what the law has laid down, my lord, that whether you have to be searched, because the court ultimately held that when the bag was opened, a bag polythene cover containing 19 rectangular broken sheets of blackish deep brown color.
Mr. Roy Chaudhary,
my lord.
My understanding query is,
my lord,
suppose your body was searched.
My lord.
No 50 notice, section 50 was not at all complied with.
My lord.
But nothing was found from your body
My lord.
except currency notes.
My lord.
And contraband was found somewhere else.
My lord, in the hand with the in the polythene bag.
In the polythene bag.
My lord, 43.
Then whether for non-compliance
My
of
lord,
50.
my lord, my lord, for that I am placing the judgment of Supreme Court. It is, my lord. Section 50 Constitution mandatory is 5 judges bench, my lord. 99(6) SSC page 172.
Page 172.
2. No, Lord, I am giving one copy. 1996 SSC page 172, para 24, 32, and 57.
Paragraph number 24.
24, 32, and 57. This is a 5 judges bench, my lord.
What it says?
My lord, para 20. I'm reading, my lord. Para 20.
No, is it answers my query?
My lord, as regards
My
your
my
lordship,
query is specific. I am not on compliance. That if 50 is not complied with,
my lord.
in a case, if from your body contraband is found, then it goes.
Goes.
But my query is, from your body contraband is not found.
My lord.
From your body search, only currency was found.
My lord.
And 50 was not complied with.
My lord.
Then what is the consequence of non-compliance of
My
50?
lord, in the other way around, I will place it in that way, my lord. From the reading of the judgment, what I found, Supreme Court has held it right when 2,400 currency was recovered from the body and section 50 was complied with, court held it was correct. Supreme Court held it was correct. You have to give it. That is 2018 9SS. In the other way around, you can place it that way, my lord.
Probably lordship, this query has
No,
been
yes,
given by the address by the Honorable Supreme Court. In the case of Dayalu Kashyap, judgment is available in record, lordship. In a short judgment.
What it's
Entire proceeding will be shared.
Your lordship's query is there, lordship. Answer to your lordship's query is there in judgment pronounced on 25/1/2022. Copy is available on the record, lordship.
What is the name of the?
Dayalu Kashyap versus State of
What it
Chandigarh.
says?
It says, paragraph 6, in the conspectus of the facts, we find that the recovery was in a polythene bag, which was being carried out on a convert. The recovery was not in person. Learned counsel seek to expand the scope of observation made by seeking to contend that if the personal search is visited by violation of section 50, the recovery made otherwise also would stand visited and thus cannot be relied upon. We cannot give such an extended view as it sought to be contended by the learned counsel for the appellant.
Yes, that was
It
my
is a query to your
If
lordship.
that be so, my lord, in other way around, my lord, 3 years, 2 months, approx. My lord, I am reading the certified copy of the order, my lord. 16.
Yes, no, 50 goes.
My lord, till then I will harp on 50.
Your submission I am recording.
My lord, till then I will hold that, my lord.
That even if it is.
My lord, this judgment of 2018 9 SCC, page 708.
2000.
18 9 SCC, page 708. It upheld the concept that when a person carrying a polythene bag and thereupon, my lord, holding the body was searched to find out if something is there in the body, then the 50 has to be given.
No, their question was not there before the court because 50 was followed in that case.
Followed in that case.
So question is not whether 50 was followed or not.
My lord, the question was replied in that way that it was upheld. When it is given, it is correct. There is no wrong in it. The court held at such, my lord, in that judgment, that when it was given, the court could have held there. But the question was raised before that court. The question was raised.
Dayalu Kashyap is by Supreme Court.
Yes, sir. Supreme. Copy is there in the record.
Okay.
My lord, here the court held, as we have already held, that section 50 was attracted in the present case. So they have held that in this case, this is a judge of 1, 2, and 3 judges, my lord. And Kashyap is not? Kashyap is two judges, and this is a 3 judges. And 3 judges bench in 2018 held that we have already held that section 50 was attracted in the present case.
Facts are different. Exactly. And thereafter many.
But here, the facts are in the polythene bag, it is found, and the body 2,400 rupees cash was found.
Okay, okay.
But here in paragraph 21, it was held that from the body 2,400 rupees was found. And from the polythene bag, it was charas one found. So the moment they have searched the body, and the court held it by a 3 judges bench in 2018 9 SSC 708.
That the 50 was correctly followed.
Correctly followed. And here it is said, as we have already held that section 50 was attracted in the present case, we need not need to decide on the applicability of Nandi to the facts of the present case. We held the section 50 was complied with. Having regard to the above position, we do not know that is different issue. Complied with. So the language is, we have already held that section 50 was attracted in the present case. So here, when 2,400 is 2,400 was recovered from the body, section 50 was attracted and it was held by the 3 judges bench that it was correct.
Okay.
And my lord, that judgment I have given by a 5 judges bench where 50 it states if not complied with, it vitiates the whole process. Now, my lord, as regards other judgments of your lordship, my lord. This is by your lordship judgment, my lord, via section 37.
That is on long delay.
Long delay. Here 3 years, 2 months. But a long delay, I am placing the certified copies of the order. 16/8/2023, PO transferred. 29/8/23, PO is transferred. 12/9/23, PO is transferred. 26/9/23, PO is transferred. 9/10/23, PO transferred. 17/10/23, accused present, Sadiq present. 30/10/23, accused present, produced. Then, my lord, 14/11/23 for CC production. 28/11/23 for production. And the last order, my lord, 11/12/23 PO is on training, fixing 22/12/23 for production and CC. And on 22/12/23 PO is on bill. Again for CC. 3 years, 2 months for CC.
Charges are not yet paid.
Not yet. This is the present certificate. I am placing, I don't have any other copy. I am giving this. These are certified copies and previously are in the record. These are the certified copies.
When charge sheet was laid?
My lord, the offense report was laid
On 3/5/2021.
3/5/2021. This is your lordship judgment.
In NCB, in the cases which are, this is a case investigated by NCB. Yes, Lord. What is the procedure? Lordship, they have to investigate, they have to file. No, difference between the investigation by police Lordship. and NCB. What? No, the difference in that they file charge sheet. First they lodge FIR, Lord. But we are. Police is filing charge sheet. Charge sheet. What And you are doing? We are filing complaint under section 36 capital A. Then after that, what is the procedure?
Not say thereafter, summons were issued and charge were framed.
Before framing of charges, whether evidence is required?
Not required.
After 2013, this law has been changed
I
by
think
our
it was
High
here.
Court Lordship.
What it says?
Because earlier, till 2013 Lordship, it was evidence before search. Thereafter Lordship.
Just like a complaint case.
Yes, complaint case.
Not-
Thereafter Lordship, our Honorable High Court took up a case. After that, law has been changed, Lordship. After filing the complaint,
What
thereafter.
procedure?
Warrant procedure.
Warrant procedure is minute.
That law is
No
there,
evidence
Lordship.
before charge.
No evidence.
No evidence before charge. Charge
So
was
it
after-
is same as
For a speedy trial.
Uh,
With the intention
war-
to complete the trial.
Warrant procedure.
police investigated cases and NCB cases are not, no difference is there, except
that you file complaint under 36A.
Capital L.
Okay.
After charge are being framed, then
Okay.
prosecution witnesses.
Yes, Mr. Roy Chaudhary. So that is your main submission.
That is my main submission, section 50 and the long delay.
So
And the judgments, your lordship has passed.
Two thousand and 21
Lordship.
charge, you filed offense report in 2021.
Yes, Lordship.
This is
So
24.
since 3 years, 2 months.
Yes,
he's
Lordship.
not in-
If my land repair is complete, then I can comment.
You have done.
My lord, this is my job, Mr.
Lordship, with regard to 50, here, Lordship, the contraband was seized from his hand, Lordship, in a polythene bag. Hand, Lordship. That is, and Lordship, with regard to second submission, that rupees were 2,400 rupees, 4,000 something has been recovered from his body. Lordship, I have seen the charge sheet and complaint. Nothing has been stated that his body was searched. Nothing on the record that it was recovered from his body, Lordship. Neither Panchanama, neither complaint, Lordship.
From where this 5,760 was recovered?
That is, Lordship, in
Page 18, my lord.
Yes, it is mentioned that it is recovered from Sushil Kumar Sahu.
Yes, Lordship.
From where it was recovered?
It is not written there, Lordship. In paragraph, Lordship, paragraph 4. Paragraph 4, page 23. Merit, Lordship.
Yes.
That thereafter surveillance was mounted in the area on dated 6/11/2020 at around 5:20 p.m. One scooty arrived at bylane number 1 Rajgarh Road, Chandmari, from side of the Rajgarh Road. There was only one person on the scooty. He parked the scooter near road and then opened the boot of the scooter and took out one white colored polythene. This scooty was Honda Activa and was grey in color and did not have number plate on the front side. On the back side, there was a number plate. The number of was so-and-so. This was according to my information. Seeing this, NCB team and 2 other independent witnesses went near him. Sri Manoj Saguna, intelligence officer himself, his team and 2 independent witnesses to him and asked him to introduce himself. He introduced himself, Sushil Prasad Sahu, son of so-and-so. Sri Manoj Saguna, intelligence officer, told him that we have an information that you are carrying methamphetamine tablet. At that time, he was still holding a white colored polythene. Sri Manoj Saguna, intelligence officer, asked him to open the polythene. On being opened, it was found that the contained 2 packets in transparent tape and brown colored tape. One of the packet was cut open. After cutting the tapes, it was found that there was another cover of the paper. It was also cut open. After cutting, it was found that there was another layer of transparent plastic cover. After cutting this layer of the paper, one transparent plastic packet was found, which contains mostly orange and some green colored tablets, on which the inscribed WY and R. Some tablets were drawn and tested with drug detected kit available with the NCB team. It gave positive test of methamphetamine tablet. On being weighted on electronic weight machine of NCB team, it was found that the total weight was 986 grams. This packet contained methamphetamine tablets, was heat sealed, and thereafter it put inside the main packet, which was given mark A, and the main packet marked A packed in brown colored tape available with them. Then Lordship, next paragraph. Similarly, another packet was cut open. After cutting the tape, it was found that there was another covered tape. It was also cut open. After cutting the layer paper, one transparent white so-and-so and given colored tablet, which were inscribed WY and R. Some tablets were drawn and tested with drug detection kit available with them. It gave positive test of methamphetamine tablet. On being weighted on the departmental electronic machine, it was found that the total weight was 858 grams. The packet containing methamphetamine tablets and was heated seal, and thereafter the main packet was marked B, and this main packet marked B and was packed in brown colored tape available with them. Total weight of methamphetamine tablets covered from 2 packets marked A and B found 1.844 kgs. White color polythene, which was so-and-so. Lordship, then we skip no contraband or incriminating documents were found. It was the boot of the scooty. The following documents were found: one photocopy card of driving license, one photocopy card of so one carbon copy, then lordship certified copy PU certificate. Lordship, regarding case, nothing has been mentioned in the complaint, lordship. In seizure memo, it is there. It is not mentioned where it is recovered from, his body or some other place. So this is a matter of trial. And even then, Lordship Dayalu says that in paragraph 7, copy is with your Lordship. Paragraph 6.
At which page?
Just in second file probably. Copy is there. I handed over last week, and I've seen that it is available in the record also. There are two files. One of bail application is on the Lordship on.
No, you may read it.
Lordship.
It is there in criminal petition.
It is in criminal petition on the top of the file.
Yes.
Paragraph 6.
Yes.
Lordship, we may read paragraph 5 also, let me clarify. The learned counsel submits that the options given to the appellant to take a third choice other than what is prescribed as the two choice under subsection 1 of section 50 of the Act is something which goes contrary to the mandate of the law and in way affect a protection provided by the said section to the accused. To support his contention, he has relied upon judgment of the Rajasthan versus so-and-so. More particularly, paragraph 19, the judgment in turn relied upon the constitutional bench judgment so-and-so to conclude that if search is made by a empowered officer or a prior information without informing the person of his right that he has to taken before the gazetted officer or magistrate or such and case he so opt, failure to take such accordingly would render the recovery of the illicit article suspicious and vitiate the conviction and sentence of the accused where the conviction has been recorded only on the basis of possession of illicit article recovered from his person. This third option stated to be given to the accused person to get himself searched from the officer concerned not being part of the statute. The same could not have offered to the appellant, thus the recovery from his visited. Next paragraph, paragraph 6. In this conspectus of the case, we find that the recovery was in a polythene bag, which was being carried on a convert. The recovery was not in person. The learned counsel seeks to
What is convert?
On a
Carried, which was being carried on a convert. What is the meaning of convert?
container.
Okay.
The recovery was not in person. The learned counsel seeks to expand the scope of observation made by seeking to concern that if personal search is visited by violation of section 50, the recovery was made otherwise also would stand visited, thus cannot be relied upon. We cannot give such extended view as sought by the contendant by the learned counsel for the appellant. And there are so many judgments passed by the Honorable Supreme Court. If the search is not from his body, then compliance of section 50 is not necessary. And here Lordship's query is, answer is to your Lordship query is there. Because admittedly, the contraband was seized from his hand. And nothing stated in either in the charge sheet or Panchnama that this money were recovered from his body, Lord. And this is a matter of trial.
And contraband was seized
From his hand, Lord. He was carrying in a polythene bag from. And regarding to Lordship with regard to delay.
If the petitioner is carrying a polythene bag, carrying
section 50 is
not required.
Not required. That is admitted position.
Okay.
Lordship with regard to delay, Lordship, my learned friend has read out some portion of the order sheet. He has not read out the entire order sheet. Lordship, what happened? I can point out from the record. After filing of the criminal petition for causing of the complaint, Lordship, the applications were filed, that case is pending before the Supreme Court, so charge should not be framed. And it is true that for some time, for a long period, court was not there. And charge could not be framed on the instance of the accused lot. Every time his plea was that case is pending, although there was no stay. And learned trial court is also not gone into this as the matter. Lordship, in this aspect, Lordship, I want to place one judgment.
No, on which dates?
Lordship.
Dates are important.
Yes, dates are important. And in Manoj Sisodia court has also observed that if there is a delay on the part of the accused or prosecution, that should be, court has to take note of that. And Lordship, in one judgment with regard to speedy trial.
No, here your submission is that because of the submission of the counsel for the accused that
Yes, Lordship, and for quite some time, the court was also not there. And accused took plea that his causing application is pending, so charge should not be framed.
his quashing application is pending before Supreme Court,
Before High Court.
before
This is
this petition.
there are two applications. One is criminal petition for causing on the ground that section 50 has not been followed.
Okay.
And one other is bail. And his ground is that there is
So
a
this in criminal petition, that is next item. The only ground is section 50.
yes, Lord.
Okay.
And Lordship, record is there. Probably record is up to June 2023.
And the next judgments are given. From June onwards, I'll give it the certified copy.
Lordship, I am placing on judgment.
Yes.
That is with regard to speedy trial. It is 2013 4 SCC, page 642. This is mainly on ground of speedy trial laws. Right to speedy trial and a right to fair trial. Lordship, in one paragraph, paragraph 7, how the trials are being delayed. Honorable Supreme Court has observed. Merit, Lordship, I'll submit to you, Lordship. Paragraph 7, even after trial commenced, the accused did not cooperate and remained non-responsive. A chart has been filed showing the manner in which the adjournments were taken by the accused at the stage of framing charge on the ground that the matter was pending before the High Court. Same case here. A reference has been made to the order dated so-and-so directing all the accused to remain absent on the next week
No,
of
is
hearing.
there anything to show that accused petitioner took this plea before
Yes,
trial
Lordship,
court?
that is
Order sheet reflects
yes, it is there, Lordship.
that the accused made a submission.
Yes, Lordship, they filed an application.
Okay.
Although there is no stay, it was incumbent on the learned trial court to pass necessary order as per law. But even then, court's Lordship, learned trial court has not taken any fact that there is no stay, even though causing application is pending. Charge could have been framed by the learned trial court, Lordship, in the meantime. For that, Lordship, prosecution may not be held responsible for delay in trial, Lordship. Because it is beyond the control of the prosecution. Lordship. We can make a submission only, Lordship. And complaint
No, but whether the trial court delayed the framing of charges only because of their petition.
Lordship, for quite some time, judge was not there. Presiding
When
official
judge
not-
was there,
Lordship,
when,
yes, Lordship, application was filed. And sometime counsel for the defense was not available. So case was adjourned. That is also on the record, Lordship. I can make a chart and I'll submit to you, Lordship.
so your submission is that there is contribution on the part of
Yes, Lordship.
petitioner also in delay.
Yes, Lordship.
Out of these 3 years, 2 months,
Because 180
he
days
also contributed.
within statutory period, we file our complaint, Lordship, within 180 days.
Okay, you give me that list.
I'll prepare and I'll give to you.
Any other submission? No, I'll not fix it. I'll fix it for orders. I'll fix a date for passing orders.
Before that, I'll give to you.
Delivery of the final order.
Lots.
Before that, you can submit that list. Any other submission?
Let's say this is the 50 will not be coming to play in this case. And with regard to delay, we are not, prosecution is not, cannot be held responsible for delay.
Prosecution is not at fault and there is contribution from the side of the accused.
Yes, but
you will provide the list.
And even then, Lordship, on second submission, when there was no stay in criminal petition, the learned trial court would have proceeded the matter as per law.
Okay.
Lordship is fixing on which date.
When will you give?
So before that, I'll.
And this criminal petition, any further submission?
No further submission, my lord, I will reply to some of the questions, please. First of all, my lord.
No, on criminal petition, you will not make any submission.
This 50, what I have made is the same. My lord, regarding section 50, I will reiterate one thing again now. The judgment placed by my learned friend is a par including, first of all, the two judges bench and a 3 judges bench, and that judgment held from the hand of the person, only a polythene bag was received. Only a polythene bag was received from the hand of the person and nothing was searched from the body. But my judgment of 2018-9 SCC 709, a search was made in the body and a currency notes were found where the court 3 judges bench held, no, section 50 has to be applied.
Okay, that we will have to answer in criminal petition.
My lord, the distinction are there. There are two distinctions. There are two distinctions, my lord. In the judgment of my lord, my friend, where it has said that only a polythene bag was received. But in my case, a seizure was made from the body and 5,750 cash was recovered. Your lordship has got it. My lord, the next 5,750 was recovered. So definitely the 3 judges bench of 2018-9 SCC, page 709, as 708, my lord, sorry, 708 has held that section 50 has to be complied with. And the second judgment of my lord friend is par inferior. And the recent judgment, my lord, I have given 2 Supreme Court judgments as regards 37 and my lord, 1 judgment of your lordship. My lord, that giving Article 21 and Section 37, my lord, long incarnation, my lord, in the behind the bar. My lord, one thing, my lord, that I want to place before your lordship. If there is no stay order, one thing is admitted by my friend, the court is not there for quite a considerable period of time. Quite a long period of time, the court is not there. If there is no, my lord, sorry, my lord, if there is no court at all, that is not my fault. And not if there is no stay order and a submission is made, my lord, a criminal petition is pending, and the court does not follow the law and just adjourn the case. It's not the fault of the prosecution. It's neither the fault of the accused. Accused will take its defense. It's for the court to decide. Court can go for framing of charge. If it is not done, my lord, it's the court which is not taking into consideration. The court, it's not the fault of the prosecution, neither the fault of the accused.
Yes.
Court is dealing the matter. For such a 3 years, 2 months, my lord, I am behind the bar. And there are 9 witnesses and plus other witnesses, as I find from the offense report.
Okay.
My lord.
When will you submit the list?
Day after tomorrow.
My lord, I will also go through and find it out. If anything is there. I will try to find it.
Because I've gone through the record, but it was not kept serially also. Some orders are here, some are there.
But I have given a certified copy from 2000, from the month of August, where it is, your lordship will find it's for quite a considerable period of time.
So should I fix it for?
Final order, my lord.
Before that, I give it.
Not before. You have to give me at
Day
least
after-
2 days ahead.
Day after tomorrow. Also.
In both the cases, heard Mr. P. K. Roy Chaudhary, learned counsel for the petitioner. Also heard Mr. S. C. K. R. learned standing counsel NCP. Hearing concluded. In criminal petition, likhable judgment, no, fixed. In criminal petition, judgment reserved. I'll deliver both on the same date. And in BA application, fix it on 10th.
10th.
Day after tomorrow, I will give notice.
Fix it on 10th of bail application, delivery of judgment on 10th, and criminal petition judgment is up.
And my lord, I've given the judgments, my lord. Two Supreme Court judgment about the long delay, my lord. Two Supreme Court judgment
Yes.
and one lordship judgment I've given. And one certified copy of those, my lord.
Into Vitarot Dibu.
Lordship, one submission, my learned friend said that this judgment is per inquiry. That is incorrect. One paragraph, Honorable Supreme Court has considered both the judgment. Lordship. हाँ क्या है? Constitution bench का judgment.
No, 18, my lord, I'm saying because it has not discussed about 2018 9 SSC. It has not discussed 2018.
14 and 19 has been discussed. The
But
judgment turned in the relied upon by the constitutional bench, judgment of this court. in
My lord,
state of
I'm not telling about that. I am talking about the factual difference of 2018 and 9 SSC 708.
Ultimately,
Why-
Lordship has to see what is the law as on date, Lordship. I'll produce the judgment. The 50 is not applicable in case it is not. It is
If it is not found in
body, Lordship.
body.
And the
That judgment I have given, my lord, where it was found in the body, currency, and it
And
was
50 is applicable.
50. is
Sorry, can you- Here, how many days?
Here, Lordship, 3 years, 10 months, 11 days, Lordship, for 1,410 days, Lordship. 10 numbers of witnesses cited, 6 examined.
1,410 days, 3 years.
3 years, 10 months, no, 3 years, 10 months, 11 days,
As on today.
Lordship.
And
In this case,
your main ground is
Main-
delay.
delay, Lordship, final
other-
complaint submitted on 18/8/2020. I was arrested on 22/2/2020. The Lordship final complaint submitted on 18/8/2020. Charge frame on 11/11/2021. First witness examined on 21
The charge frame down.
on 11/11/2021.
And complaint was submitted on
18/8/2.
18/8. You were arrested on 22/2 and first witness examined on
First witness examined on 21/20/2022.
and how many witnesses are already examined till now?
Till now, 6 witnesses examined. Last witnesses examined on 27/2/2023. In the meantime, what happened, Lordship? They have filed a petition by their special PP to issue bailable warrant against their officer, Lordship, namely one Manish Modi, on 15/3/2023. He is one of the official witness, Lordship. He has cited witness in the final.
How many witnesses are there? Total listed witnesses?
Total 12 number of witnesses.
6.
10 witnesses.
No, 11 number. DJ Hazariya log logai dise na piso. Piso Hazariya log logai dise.
No, sorry,
11
sorry to kati this.
Ten. Naikata. Anise do. Anjani hoi gol. 11 number of witnesses, Lordship. Out of 11, 6 witnesses examined, Lordship, till today. And Lordship, last witness examined 27
February. In February.
February last year. So, Lordship, in this case, final complaint, in earlier occasion also I made a submission before your Lordship regarding the final complaint and charge sheet. Because Lordship, Thana Singh judgment is there. In that case, the Honorable Apex Court passes judgment regarding the NDPS Act, Lordship, where no adjournment shall be made by either of the party, Lordship. That direction is there in NDPS cases, as per Thana Singh, Lordship.
What it says?
no adjournment at all. 3091 shall be applied by the court during the trial. Thereafter, on the basis of that, Lordship, our High Court
309 means I have not understood.
309 CRPC, Lordship.
So suppose there are 100 cases, NDPS cases are pending in the trial court. How it will conduct the trial?
In that case also, Lordship, this direction was there in that case, Lordship. There is specifically mentioned, Lordship. Because it is under NDPS Act, Lordship.
No, what Thana Singh says,
Thana Singh says, Lordship, the procedure how to make the adjournment and all.
on which, what is your point? Specific?
My point is that, Lordship,
Once
it's a
trial started, no adjournment.
no adjournment, Lordship. No adjournment by the either of the party, Lordship.
Where? Okay.
Lordship. In adjournment, Lordship will find at
Para 7.
para it start from 7. 309 also discussed here, Lordship. In Husainera Khatun also discussed in this case. Last paragraph of this para 8, Lordship. After 4 line, after Husainera Khatun, Lordship. That something in this case is duty bound to protect and uphold until the statutory provisions are in place. We direct no NDPS court would grant adjournments at the request of a party except where the circumstances are beyond the control of the party. This exception must be treated as an exception and must not be allowed to swallow the generic rule against the grant of adjournments. Further, where the date for hearing has been fixed as per the convenience of the council, no adjournment shall be granted without exception. Adherence to this principle would go long way in cutting short that queue to the doors of justice. So this is the procedure followed, and the way also discuss how to examine the witnesses in the next it start from para 10. So, Lordship, in this case, following this case, Lordship, our High Court passed a judgment to this one. Regarding the customs, DRI and NCB cases, Lordship. That is in the year 2013, Lordship. After a long hearing, Lordship, whole the law has been changed. Because these are the cases based on the complaint. And then early before 2013, there was a case regarding this. Oh, they have to follow the summon procedure. Summon procedure they were adopted by the trial court. That thinking about that, Lordship, his Lordship passed the order. That Lordship changed the law and made it as pass a direction to adopt the warrant procedure, Lordship. They have to, after filing the charge, then Lordship frame the charge and then call for the witnesses. Just with the intention to complete the trial as early as possible. For a speedy trial, Lordship. It is in 2014 for GLR 595. This one, copy. Here also Husainera Khatun discussed, Lordship. Right. Very good. Sir. Para number 21 and 22, Lordship. Because before that, Lordship, the in complaint cases, normally the witnesses call for then they took the witnesses and thereafter charge frame. Again, these witnesses called for and again examined by the defense lordship. That was the procedure at that time, lordship. This honorable court had an intention to complete that the complaint cases as early as possible, lordship. Article 21 also discussed in this case.
Okay.
So one more citation is also I would like to refer, lordship. It is 2017, though it is not NDPS Act, but it is regarding the session tribal cases. In paragraph number, the other part I read.
2 years.
2 years, within 2 years, lordship, 29.1, paragraph number 29.1.1.2. That magisterial trials where accused are in custody be normally concluded within 6 months, and sessions trial where accused are in custody be normally concluded within 2 years. So in our
It's paragraph number 28.
29.1.2, it summed up after discussion, lordship. Husainara Khatun and all discussed here, lordship. And I don't want to read all the things, lordship. It has been summed up.
So your main submission is that 3 years, 9 months, 10 months.
I'm inside the jail, and lordship, out of 11 witnesses, only 6 witnesses are examined, and since February 2022,
They have not examined any witness.
any witnesses, lordship. And in this case, lordship, the person is from he is from Silchar, lordship. Allegation against him.
What was the seizure?
Seizure was methamphetamine tablet, lordship, 5.5 from 5 persons who were boarded in the vehicle, as alleged that I was driving the vehicle, lordship.
How much was the quantity?
5.15 kg. And out of 5 accused, lordship, 1 expired during the trial, lordship, and 1, lordship, but others are
How many petitioners are there?
only 1, lordship.
And others are?
Others are still inside the jail, lordship.
Okay.
And lordship, I made several requests before the court. Make a calendar so that which witness should be called for. In that case, the special PP, he has made objection to that regard, lordship, because in one order it is reflected that 3 witnesses' name has been mentioned, when subsequently on his request that has been changed. Even after that, lordship, it is a matter of 2022. So even after that also, witnesses are not called for since February, lordship. So and he has filed an objection in this regard, lordship. In his paragraph number 4, he has mentioned that I filed a petition before the court on 11/10/2023. I applied certified copy of the trial court, lordship. In the certified copy, no case has been fixed on 11/10/2023, where he made the allegation that I filed this application and took the adjournment, lordship. In this case, several times I made the prayer before the court, lordship, just to conclude the trial. I never filed any bail application before any authority, lordship. Earlier, some other council filed a petition that was rejected at the initial stage. It is 11/10, no case was fixed by the trial court. It is from 4/10/2023, 4/10/2023, LCR call for it is till 4/10/2023. Then 4/10/2023, no case is fixed on 11/10/2023. How it is possible that I have filed a petition before the trial court for adjournment of PW7? PW7 never appeared before the trial court. Who was the PW7, lordship? My only submission before your lordship, still 5 or 6 witnesses are yet to be examined, and he is a local person, Lordship, for about 4 years running, Lordship. With any stringent condition, he may be released, Lordship. In another case, Lordship order is there. In that case, all the citations cited before this by this honorable court.
Yes, Mr. Kyle.
Lordship.
Main submission is that long delay.
Lordship, I have seen that out of 11 witness, 6 has been examined. Lordship, with regard to PW 7, IO has
PW 7 has not yet been examined.
Lordship, as per my information, chief has been completed, cross was, no. As per my information, Lordship. Otherwise, Lordship, I have to make a statement from the order sheet. This is the information given by the IO to me, Lordship. And on that basis, a field defeat was filed.
Certified copy I have.
And Lordship, with regard to parity, Lordship, recently in case of Tarun Kumar, Honorable Supreme Court clearly says in case of bail, there cannot be any parity.
No, they are not asking for parity.
No, they are submitted some judgment that
No, I'm clear.
Judgment only to show that
Law points has been decided by this court.
even then, Lordship, in case of bail, Lordship, I am reading.
in a given case, person may be detained even for a longer period.
Yes,
That
Lordship.
is your submission.
Yes, Lordship. But in case of NDPS, that cannot be equated with other culprits, other offences, Lordship. Because Lordship, on last occasion today, I'll give a Hira Singh in paragraph 8.52, Honorable Supreme Court has observed what is the purpose of behind introduction of the NDPS Act, Lordship. And we cannot ignore that it will affect the society. In one judgment, Supreme Court observed that murder can be let off, but in case of drug NDPS case, it's destroyed the fabric of the society.
No,
So-
but for that trial has to be concluded.
Yes, Lordship, on other side also, because one judgment in earlier case I've cited, I'll give you Lordship. Fair trial and speedy trial is the right of the accused, Lordship. That cannot be denied. But Lordship, you have to see the nature of the case. It cannot be applied straightforward formula for all cases.
No, but Apex Court is applying it in
No, Lordship.
NDPS cases.
No, in case of Mohammed Muslim, Lordship, he was in jail for more than 7.5 years. And out of 64 witnesses, Lordship, only 34 witnesses were could be examined.
Now, not Muhammad Muslim only.
Lordship,
There are other cases.
yes, there are
where-
three judgments. One is Ravi Prakash. That cannot be said that some law has been laid down, Lordship. That is purely on the facts of the present case.
Yes.
In that case, he was he was a co-passenger in other case.
No, what is my query again is,
Lordship.
I have seen in at least 4 to 5
Yes,
cases.
there are three judgments.
Not 3, more than that.
Apex Court, Lordship, I think some other judgments are also there. Then
No,
Lordship,
Apex Court's judgments are there where the petitioner who were facing trial in cases involving commercial quantity of contraband
yes, Lordship.
were released on bail merely because they were behind the bar for about 2 years.
No, Lordship, there are one judgment from West Bengal that went to Supreme Court. Supreme Court has upheld the judgment of the Calcutta High Court where the case was granted bail after 2 years. Lordship, let's see the facts of that case also. That is also important, Lordship. What was his involvement? Then in case of Nawaz Sharif, Honorable Supreme Court cancelled the bail of the accused because he was found in the car where the contraband were seized. His bail was cancelled. In Ajay Kumar Singh also bail was cancelled. And in all these judgments are of 2 judges bench. And in case of Mohit Agarwal, Lordship, there was a 3 judge bench where court said that In any case, section 37 is applicable. That also cannot be ignored, Lordship. Yes, speedy trial and fair trial is the right of the accused. But fair, under what circumstances, Lord? In one of the case, in our High Court, Honorable Supreme Court says that court has to balance the right of the accused while deciding the bail application. Everywhere we cannot apply Article 21 laws. It depends upon the facts and sequence of the case. And we cannot also cite that Article 21 is there. Speedy trial and fair trial is the right of the accused. That cannot be denied in any case. But lots of ways to keep balance considering the nature of the case.
No, what is to be considered?
So,
Suppose there is a huge quantity of contraband seized,
then
they will not get bail.
Then lots
There
of
has to be some
that
criteria.
That criteria is no, lots may fix the criteria. And with regard to completion of trial, I think there is no guideline from either from this Honorable Court or by the Supreme Court. Also.
No, completion of trial fixed guideline may not be stated, only in this.
But
this-
even new
this is-
new criminal act which has been passed.
New criminal law,
that is there.
that is not respect.
No. That is also
What is there in the new criminal?
Within
act?
3 years trial is to be complete.
Otherwise,
They will be entitled to bail
Then it is
indirectly.
ordered-
then that spirit will come.
No, Lordship, because as on date, nothing has been fixed. In one of the case, Lordship, 2012, Supreme Court said we cannot fix the time limit. Because the
Yes,
fact
it
that
is not possible.
it is not possible. Sometimes court is not there. Sometimes some circumstances, Lordship just sometimes said that one case take about 2 or 3
Now, the
hours.
question is whether for whatsoever reason, if the trial is not complete, whether the accused will get benefit of conditional liberty.
Then Lordship has to see, as held by the Honorable Supreme Court in Manoj Sisodia's case. Who
Which
is
case?
In Manoj Sisodia's case, that Delhi Chief Deputy Chief Minister's case, Manish Sisodia's case. In that case, Supreme Court has directed the trial court to fix the trial within a specified period, and simultaneously calculate the period if anybody takes time, either accused or prosecution, that is to be taken care of while calculating the time.
But we have seen in most of the cases where NCB is on the other side.
No, Lordship, that is correct. Regarding Corona period, about 2.5 years, virtually there was no trial. Witness could not come, and there was no facility for video conferencing also. And we have requested the Honorable Court to allow us to examine the witnesses through video conferencing. In 2 or 3 cases, that has been allowed also. Some mechanism has to be evolved by.
To that triggered, my submission is that Lordship, NCB was the only party, Lordship, only other side who brought the witnesses during the Corona time, because I am the trial lawyer, I know about the NCB, Lordship. Only NCB is the person who brought the witnesses and examined. I appeared many cases, Lordship, during that period.
Okay. Here, what is your other submission? They have caused delay or not?
That I have to
No,
check
is,
from that.
is it your submission or
Lordship, my affidavit says that.
only once
That is there.
which she is countering that on that date?
And as submitted by my learned friend, that application is filed, issuing warrant of arrest against the witnesses also. So we are not taking leniently that trial should be delayed. Against our own officer. they are
No,
free.
suppose prosecution is not at fault, but still trial is not proceeding. Then
Lordship is to consider the whose why the trial is delayed, for whose fault. That court is Lordship is to take into consideration.
Okay.
And in this case also, since record is there, as per details, I'll prepare a chart and submit to you, Lordship.
We never took any adjournment in this case.
But in this
We
case,
made several requests to the court as well as the special PP, Lordship. Kindly call for the witnesses as early as possible. At my
When
insistence,
will you give that chart?
Lordship,
You want to give a chart?
yes, Lordship.
When? Day after tomorrow.
Day after tomorrow, in both the cases.
Okay, then
And my lord, regarding this 2 years, lordship, Tapas Mandal and Mal Mandal, I have placed lordship, it's a regarding this.
there are many,
There are many judgments in
At
our
least-
favor also,
yes,
in favor of NCB also.
yes, but as regards the period which would be regarded as a long incarceration.
No, lordship, then this is another question of debatable question. In Mohammed Muslim, Honorable Supreme Court says that earlier it was a, there was a law that 436 capital level will not be applicable in case of NTPS cases. But from Satish Prasad until and Mohammed Muslim. on the-
436 is applicable.
Now it is applicable. So if we take into consideration 436, then maximum punishment, half of the maximum punishment to be calculated. And it will.
But Mohammed
ma-
must
ma-
discuss the
maximum-
37 also, lordship.
Maximum punishment is 20 years. Then there is a question of 10 years, half of the punishment. If you consider minimum punishment, but section 46 says the maximum punishment to be calculated. So that question is also come.
My lord, what happened in the trial court, after 6-7 years, all the accusers got acquitted because of their fault, lordship, there are procedural lapse. I have lots of cases when after the trial, lordship, we never filed a bail petition, lordship, trial we have concluded. And after 6 and 7 years, the person got acquitted from the trial court, lordship. This is the procedure.
That is all to the different aspects of the
Heard
matter.
Miss S.K. Nargis, learned counsel for the petition. Also heard Mr. S.C.K.R. learned additional subject, learned standing counsel NCB. You will give on 5th.
Lots.
This is on
It is also. No? It is June.
10th.
Lots.
Let this case be fixed for delivery of orders on 10th of January.
Lots.
Alright.
Machu.
Verify করি না আমার ভালো লাগে।
Thursday পড়েছি, টাইম নেবো নি। Thursday পড়েছি তো, ঠিক আছে? Thursday পড়েছি, টাইম নেবো নি।
My lord, we had filed for quashing of the FIR. In the meantime, it is charge sheeted. Now we file another criminal petition for quashing of this charge sheet. So both may be clubbed. I'll give you the case number.
Then whether it will remain,
My lord,
this petition will also remain.
yes, yes. Because normally what we do, we come for quashing of the FIR, charge sheet, and if cognizance is taken, cognizance order. Now, here we have challenged the charge sheet. Meanwhile, it is, sorry, here we have challenged the FIR. Meanwhile, it is charge sheeted, cognizance has been taken.
You have preferred another.
Yes,
criminal petition.
against the charge sheet and order of cognizance. That is criminal petition 998 of 2023. Both may be clubbed, my lord.
Heard Mr. F. Khan, learned counsel for the petition.
998.
Also heard Mr. K.K. Das, learned additional public prosecutor. Learned counsel for the petitioner has submitted that in the instant petition, the petitioner has preferred, no, in the instant case, the petitioner has preferred. No, the instant case has been preferred by the petitioner under section 482 of the Code of Criminal Procedure for quashing of the FIR. Quashing of the FIR. On the basis of which Link PS case number 506/2021 was registered. Stop. It is submitted by learned counsel for the petitioner that in the meanwhile, charge sheet has also already been laid in the said case, and the petitioner has also preferred another criminal petition, which is registered as criminal petition number 998/2023. Praying for quashing of the charge sheet as well as the order of taking cognizance against the present petitioner. And it is submitted by the learned counsel for the petitioner that both the cases may be taken up together. Learned additional public prosecutor also does not opposes the said prayer, hence the prayer is allowed. Let this case be again listed after 2 weeks.
2 weeks, my lord.
After 2 weeks, along with criminal petition number 998/2021.
My lord. Obliged, my lord.
You have filed
I filed the affidavit.
affidavit.
I filed.
What is this?
My lord, this, my lord, regarding, my lord, maintenance case, my lord. Here, my lord. Our, my lord, in this case, my lord, legal issue, my lord, whether the subsequent petition is maintainable. First petition, my lord, she filed, my lord, a petition under section 125 CRPC, my lord, in 2001. 2001, my lord. And that was, my lord, decided by the competent court, my lord, by passing order in 27/5/2005.
Thereafter,
Thereafter, my lord, she filed another application, my lord, under section 3, my lord, of protection of women from right on divorce, my lord, claiming her stridom as well as, my lord, other Maharana as well as other, my lord, maintenance. That was also allowed, my lord, in 2000 by order dated 25/5/2004.
yes.
Now, after 11 years, my lord, she filed fresh application under section 125 CRPC again before the family court
Your
By-
submission is 127 ought to have been filed.
by suppressing everything.
May I submit, my lord?
Let him complete.
My lord.
By suppressing everything,
Okay.
not a whisper about the earlier case,
In the present case.
lordship. That was allowed by the landed family court.
And now you are before this court for
For against the judgment, my lord, 18/1/2020, where only the second petition has been allowed. So second petition is clearly barred by res judicata, principle of res judicata, my lord. And there is no explanation regarding the delay of 12 years of filing subsequent petition.
okay.
So on this principle, my lord, second petition, my lord, on the same set of, my lord, facts, which was already decided by competent court, they have not preferred any appeal. They have not filed any petition for modification.
The earlier petition was allowed
Allowed,
by order dated 27/5/05.
lordship.
What was the maintenance? which was-
Maintenance was at that time, it was granted 5,000, my lord.
No, my lord, 2000.
500, my lord,
500 per.
500, my lord, and 500 to Silan,
500 per head.
lordship, per head.
So total compensation, total maintenance allowance was of
2000 rupees. my lord.
2,000, my lord. And as per our information, it was subsequently enhanced, my lord, up to 4,000. That order I do not have, my lord. So Silan already became major, my lord.
And in the present later filed 125 petition, what was the relief?
3,000,
Only for the wife.
only for the wife. She made claim only for hers, my lord.
Okay. Is there any other submission?
Regarding, my lord, only, my lord, legal issue, my lord, res judicata, my lord.
You have any authority?
my lord. And secondly, my lord, the Rajneesh Kumar latest judgment, my lord. The wife, my lord, if filed my lord petition, she has to my lord disclose about my lord all earlier cases. That was also suppressed. So she approached the court, my lord, by suppressing material facts. On that ground, my lord, petition ought to have been rejected. This is my lord clear abuse of process of court, my lord.
You contested the later case.
Lordship, I filed.
You have pointed out to the
everything
court.
I have pointed out and submitted. And that court, my lord, itself passed the order.
Okay.
That court, my lord, ought to have been, my lord, called for the earlier records. That was also not done.
What is this?
This, my lord, regarding, my lord, red judicata, my lord, paragraph 17, 18, my lord. Yes. Seventeen, 18, and 19 also.
Application of res judicata in 125 proceeding.
No, this is, my lord,
General principle.
general principle.
Now, do you have any authority where it says that in
125.
125 proceeding also res judicata would be applicable?
That I have to.
Okay. Because it may not be applicable.
Because 125 proceeding is a, my lord, civil nature, my lord. This is not a criminal nature. And here, my lord, paragraph 19, my lord. The basic principle, my lord. Paragraph 19, my lord. But the lordship got it.
Yes.
But the question as to whether a citizen should be allowed to challenge the validity of same order by successive petition under Article 226 cannot be answered merely in the light of the significance and importance of citizens' fundamental right. The general principle underlining the doctrine of res judicata is ultimately based on the consideration of public policy. One important consideration of public policy is that decision pronounced by a competent court of jurisdiction should be final unless they are modified, reversed by appellate authority. And the other principle is that no one should be made to face the same kind of litigation twice, because such a process would be contrary to consideration of fair play of justice. So same principle, my lord. I have already, my lord, faced the same proceeding under 125 CRPC.
Okay.
And thereafter she, my lord, filed another application. That was also allowed. Now after 12 years without, my lord, any explanation. And regarding non-explanation, my lord, this all court also, my lord, rejected one similar petition, my lord. Here petition was filed after 35 years, my lord, of seeking maintenance. That was allowed by trial court. Honorable High Court set aside the order, my lord. Lord.
Anything else?
No, Lord.
Yes.
My lord, in this case, my lord, both the parties, my lord, my lord, the first party had filed a divorce petition, my lord. My lord would kindly come to page, my lord, 14 of the criminal petition, my lord. The said MR case, my lord. As my senior had referred to. My lord, the outcome of that case was that an amount of rupees 2000 was given as a maintenance amount. But my lord, that amount was never paid to us till date. That is the whole reason why we had filed the FC criminal case number 341 of 2015 for maintenance, for seeking maintenance. Because although the honorable court below had given us the relief of rupees 2000 for me and my children, but the said amount was never paid. And my lord, the other case, my lord, the miss case 249 of 2001, which I had preferred, my lord, which my lord would find at page 20, my lord, of the criminal petition, my lord. In that case, I had only got relief regarding my Dinmohar and the maintenance only during the Iddat period, my lord, those 3 months.
That was under section 3.
Section 3 of the protection of women under Muslim laws, my lord. That act. Apart from that, I have not got anything, my lord, till date. That is the case about. That is why we had to subsequently file the FC criminal case, my lord.
But in your subsequent case, you have not disclosed that you have.
I have disclosed, my lord. If I may take my lord to page 20, page 64, my lord. Page 64 of the criminal petition, my lord. Sorry, my lord. Page 58, my lord. Page 58 of the criminal petition. This was an observation made by the honorable court below in that FC 341 2015 case, my lord. This was a judgment passed by the honorable court below. If I may read, my lord, the first party, that is me, further claimed that the second party, in spite of having sufficient means, has neglected, refused to maintain her. There is nothing in the record to show that the second party has ever paid any maintenance, either in cash or kind, to the first party since she has been living in her parental home. In the case in hand, the second party is a government employee and he has a permanent source of income. He's a CRP employee, my lord.
No.
And therefore, he has means
The
to make.
submission of petitioner's counsel is as per Rajneesh versus Neha, when you
My lord.
prefer a application under 125,
My lord.
you have to disclose
My lord.
whether any other case is pending.
I have disclosed, my lord.
Where?
My lord would kindly come to page 94 and 96, my lord, of my affidavit, my lord. The same has been, this is also the judgment. This is the same is reflected in the judgment, my lord. Both the cases I have referred to. And
Where
this
is
has
your
been-
affidavit?
Affidavit.
Affidavit in opposition.
Page 94. It's my affidavit.
94.
I think judgment of a judgment of a LCR in my lord. Lords would kindly refer to paragraph 3, my lord, where the honorable court below has observed that I had filed both the cases, one under that section 3 case, my lord, and the other MR case also, my lord. It is reflected in the judgment. I have not suppressed anything.
No,
I followed the extant law as per Rajneesh versus Neha.
It is in paragraph 3 of the judgment.
No, you have submitted affidavit.
My lord, I have. My lord, in fact, my lord would find it at in page 53 also, my lord, of the criminal petition filed by my senior from the other side. 53, man.
Affidavit 9. Your affidavit is not there on record. When have you filed? Okay, where at page 53, what are you?
My lord. My lord, at page 53, paragraph 3, my lord, would kindly come.
Yes.
My lord. My lord would have, my lord, thereafter, my lord. Thereafter, the first party filed a case in the Court of Additional CJM Borpeta under Section 3 of Muslim Women Protection of Right on Divorce Act. This is the case which I have disclosed before that honorable court. My lord, and also reference has been made to case number, and my lord, it is seen in this order that I have got, he paid rupees 3,000 for iddat and rupees 10,001 rupees for fair provision and rupees 9,851 as den mohar to the first party, that is me. He stated that last 14 years, the first party did not lodge any case claiming so and so for each child of the first party as per order in MR 248 of 01. My lord, both the cases I have referred to, my lord. Because this MR case is the first case, then this Din Mohar case is the second case. So, my lord, there is no question of suppression, which my senior has alleged. There is no question. The only reason why we had approached the honorable court after so many years was because we didn't get the mandate. I agree, my lord. I am also on that we had approached after a few years, but because we didn't get the maintenance. That is the moot question in this case. That is the case all about. So there is no question of suppression, my lord, as has been alleged. And re judicata therefore doesn't come into play, my lord.
Why it doesn't come?
My lord, because in that case, my lord, the first case, my lord, we had already approached, we had got the relief, but we didn't get the amount, my lord. That is why subsequently we had to approach the honorable court below. We had only got the relief under the personal Muslim law, my lord.
No, when there was a case, favorable order in your favor in earlier case.
My lord.
If you had not received the
My lord.
amount,
My lord.
you could have prayed for execution of the order.
My lord. My lord, may I submit? My lord, may I seek some time to get some clarity from my client, my lord? I have also recently been handed the brief. Some time may be given to me as well. I shall also seek
And
clarity.
Mr. Ali,
regarding
you
this.
also come up with specific authority that subsequent 125 proceeding is not maintainable. Not general principle. Okay.
My lord.
Heard Mr. R. Ali, learned counsel for the petitioner. Also heard Mr.
P.R. Sharma.
P.R.
Sharma.
Sharma, learned counsel for the respondent. Learned counsel for the respondent sought some, during the course of hearing, learned counsel for the respondent sought some time for seeking some clarification from the respondent for answering certain queries posed by this court. The prayer is allowed. Let this matter be listed after 2 weeks.
As part of.
As part of law.
Highly obliged.
Mr. Lordship, I am appearing on behalf of Mr. S.P. Das. Lordship, respondent side has not filed an affidavit to counter this case.
You are for the petitioner. You are respondent or petitioner?
Petitioner.
No, you want to file and
No, sir.
they don't want to file.
If
Because it's a mandatory provision, the statutory provision, they have to pay the amount as directed by the appellate courts. And in last 4 times, they have taken time.
No, what is the matter?
It is a payment of, in case of criminal appeal number 4 of the 2003, the last sessions are Borpeta as directed to pay 25% of the compensation amount under section 148 of the
20%.
25%.
25%.
Yeah.
What law says? 143.
148, sir.
148.
Yeah. Can I read, sir?
Yes.
Subsection on notwithstanding anything contained in the Code of Criminal Procedure 1973. In an appeal by the drawer against conviction under section 138, the appellate court may order the appellant to deposit such sum which shall be minimum of 20%,
It is 20%.
minimum of 20%. It may be maximum. Of the fine of compensation awarded by the trial court, provided that the amount payable under the subsection shall be in addition to any interim compensation paid by the appellant under section 143A. That is the provision.
So it can be more than 20% also.
Maybe.
Yes.
Lordship.
Actually, they are using the delay practices, sir.
You are not ready today.
If they do not desire to file any affidavit, any counter affidavit.
There is no to file any
lordship-
affidavit in this case.
Your
sir.
lordship, your lordship may be pleased to fix the case in usual course of hearing.
No. Is there any stay in this
No,
case?
sir.
No stay.
Lordship is a statutory provision to pay the amount.
Interim order is there. An interim order is running against you.
Yeah.
Therefore, they are praying for usual course. Let him come prepared. I'll give a fixed date.
The problem is that, Lordship, from last February, they're taking times in every.
No. You are not the engaged counsel. He's not the engaged counsel. He's
But I think he is appearing in the last 4 days, last 4 times.
You have to come prepared next time.
You may please fix the on 9 January or 10 January.
I'm fixing a date as per. Yeah.
7 lakh. প্রতিবারে time গুলো আছে।
23.
Would it possible to that?
আরো আগত দিব পারে। 19 January. Heard Mr. A. Islam, learned counsel, appearing on behalf of Mr. S.P. Das, learned counsel for the petitioner, who submits that he is not prepared and seeks some time for preparation for making submissions in the case. Also heard Mr.
A.
Kolita, learned counsel for the respondent, who submits that the petitioners are taking time on one or other text on many earlier occasions and an interim order, and they are enjoying the benefit of interim order passed by this court in favor of the petitioner. Hence, prays for an expeditious hearing. Considering the submissions made by learned counsel for both the sides, let this case be listed for final disposal on 19/1/2023. Come prepared on them.
May please, Lordship. Yes, ma'am. Here I am appealing for the respondent, my lord. Basically, this matter otherwise, my lord, become infructuous, my lord. Because, my lord, the NCB has challenged the order passed by the learned CJM, my lord, whereby Jimma of a truck has been given to us, my lord. Because Customs provides, my lord, I have to approach the authority first, my lord. Accordingly, I approach, my lord. Thereafter, my lord, the Customs assessed the value of the vehicle and demanded ₹5 lakhs to be deposited by me before the custom authority. But at this stage, my lord, the financial condition of the, my lord, petitioner is not so good, so that he submits such huge amount, my lord. So I again file an application before the authority to reduce, if possible, the amount, my lord. But that has not been considered till date, my lord, by the authority, my lord. On last occasion, they were directed to by this court to, my lord, take instruction whether that can be reduced by the authority. So that is the stage, my lord. Otherwise, my lord, petition become infructuous, my lord.
No, petition has become you are the petitioner.
No, NCB has preferred this.
NCB.
So let us, my lord, my friend take instruction.
What is your submission?
Maybe my senior has received instruction. Please on let's.
Okay. Third, Miss R. Deka,
M Decca.
M. Deka, learned counsel for the petitioner, learned counsel submitting on behalf of Mr. S.C. Kayal, learned standing counsel for who is the standing counsel, DRI,
Last stop.
Custom.
standing counsel.
DRI, DRI.
Who is the petitioner? Standing counsel, Directorate of Revenue Intelligence, Guwahati. Who submits that, who prays for an adjournment on the ground that the learned standing counsel DRI has to seek instructions from the petitioner as regards as to whether the matter has become infructuous or not.
So, my lord, if my lord, that application be considered, that instruction may be collect.
And learned counsel for the respondent has submitted that. What is your submission?
My lord, I have filed an application to reduce the amount, my lord, the surety amount, my lord. If possible,
That
that
is-
can be reduced by the authority, my lord. If possible, that instruction he,
No, but how that is relevant in this case?
otherwise, yes, my lord,
That is not relevant in
not
this.
relation, my lord. But
Let him seek the instruction
My
whether
lord.
this petition has become.
otherwise, yes, my lord. Otherwise, in this proceeding, my lord, that cannot be.
Considering the submissions made by learned counsel for the petitioner, where is allowed. Let this matter be listed after 2 weeks. In the meanwhile, the petitioner may seek the necessary instructions from the petitioner as regards whether this case has become infructuous or not.
That's okay.
My pleasure, Lordship, just as per this note dated 28/12/23, note, neither ID card nor answer notice has been received based upon the sole respondent.
So we have to wait,
Taken steps on,
or you will take fresh steps.
which is fresh steps.
Third, Miss
D. Dutta.
D. Dutta, learned counsel for the petitioner. It appears from notice, office note dated 28/12/2023 that neither AD card nor unserved notices or any service report in respect of the sole respondent has been received back till now. Stop. Learned counsel for the petitioner submits that the petitioner may be allowed to take fresh steps on the sole respondent in view of the office note referred above. The prayer is allowed. The petitioner shall take fresh steps for issuance of notice to the respondent by registered post with AD within 3 days from the date of this order, returnable after 4 weeks. Stop. Let this matter be listed accordingly after 4 weeks.
Yes, Lordship.
May I please, Lordship? LCR was also, Lordship. Trial court LCR was received. The petitioner is convicted for 2 years by the learned trial court, and thereafter learned appellate court appealed the conviction order passed by the learned trial court. Lordship, as per the office note, AD notice for the respondent 2 is not served, Lordship. AD is not returned.
Now what is to be done?
Lordship, I is for suspension of sentence and grant of bail. The petitioner is behind the bar, Lordship. Last till more than 190 days, Lordship.
What is the offense?
Offense under section 387, Lordship. The Lanark trial court convicted the petitioner for 2 years. Imprisonment for 2 years. 2 years.
Yes.
The 2 years, but otherwise, 2 years case, we don't have any objection. I got it.
On the date of order.
No, তার আগে তো নাছিল।
Nothing.
More than 3
Heard Mr.
DCTM.
D. Sutia, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. The LCR which was called for in connection with this case has been received.
GR case. 618 GR case number 2017.
Has been received. However, notice to respondent number 2 has not yet been received. Neither answer of notice to respondent number 2 nor AD card has been received back. Hence, the petitioner is directed to take fresh steps for issuance of notice to the respondent number 2 by registered post with AD within 3 days from the date of this order, returnable after 3 weeks. Let this matter be listed accordingly after 3 weeks. In IA, this interlocutory application has been filed by the petitioner Rahul Datta, praying for suspending the sentence imposed on him by learned trial court in GR case number 618/2017, by which learned Sessions Judge Diffu has which was upheld by the learned Sessions Judge Diffu in criminal appeal number 3/2023.
2020.
No, whether that Sessions criminal appeal record has arrived.
No.
That would also be required.
Yes.
Yes.
Auction 618 I see.
Session to
It was not received also.
पहले वाले केस में though the earlier case, main case, though the LCR of GR case number 618/2017 has been received. However, the record of criminal appeal case number 3/2023 has not yet been received from the Court of Learned Sessions Judge Diffu. Registry to issue requisition for registry to issue requisition for calling the record of criminal appeal number 3/2023 from the Court of Learned Sessions Judge Diffu.
2020.
2020 from the Court of Learned Sessions Judge Diffu. In the other case, next case, what was it? 3/2020. 3/2020. The applicant has preferred a criminal revision impugning the finding of learned session judge in this, impugning the finding of first appellate court, which has been registered as criminal revision petition number 430/2023. What is your ground for suspension?
Lordship, there is a misconception of law. The learned trial court passed a judgment on the findings of the learned trial court is that the convict person failed, the accused person failed to prove his case. But the law is that prosecution must prove the case beyond reasonable doubt. And there is a contradiction of appreciation of evidence, which is admitted by the finding of the trial appellate court is that there is a minor contradiction of PWDs, the prosecution witness, but which is not the finding appellate court. The finding of the appellate.
Learned counsel for the petitioner has submitted that the learned first appellate court has erred in upholding the judgment of the trial court passed in GR case number 618/2017, in as much as there is lot of contradiction amongst the testimony of witnesses, which and the finding of conviction arrived at by the first appellate court should not have been arrived at. And there is every possibility that in the connected criminal petition, criminal revision number 430/2023, the petitioner may get an order of acquittal. It is also submitted by learned counsel for the petitioner that as the petitioner has been sentenced to undergo imprisonment only for a limited period of 2 years. Hence, if the sentence imposed on the petitioner is not suspended during the pendency of the connected criminal revision petition 430/2023, the petitioner may be prejudiced if the disposal of the said criminal petition takes time and ultimately the petitioner is found to be innocent. Stop. Considering the limited duration of the sentence, the short duration of the sentence with which the petitioner has been punished in this case, learned additional public prosecutor also does not opposes the prayer for suspension of sentence during the pendency of the connected criminal revision petition. Hence, considering the entire aspect of the matter, the sentence imposed on the present petitioner, namely, what is his name?
Rahul Datta.
Rahul Datta, in GR case number 618/2017, which has been upheld in criminal appeal number 3/2023, is hereby suspended till the pendency of during the pendency of the criminal revision petition number 430/2023, and the petitioner, above named petitioner, is allowed to remain on bail.
Now he is in custody.
No, now you have to go on bail.
Yes.
He is allowed to go on bail during this period on furnishing a bond of ₹30,000 with one surety of like amount, subject to the satisfaction of learned, which was the original court?
Judicial Magistrate First Class Karbi Anglong Entity.
Subject to the satisfaction of learned Judicial Magistrate First Class Karbi Anglong
Diffu.
Diffu. during the pendency of the instant criminal revision petition number 430/2023. With this interlocutory application is disposed of.
Highly.
Also, next item 45, the matter may kindly be taken up next Friday. This is regarding correction of the order passed by this court, passed by the Honorable Justice, retired Justice A. Bothakur.
45
Next item, 45.
Friday. And other matters,
I think 50 lordship may be taken on Friday because we have obtained instruction in this case.
Friday maybe, we maybe till
Or next week.
next week.
Yes.
You take other leftover matters, Courtmaster will give dates.
My lord, there is one small prayer for item number 47. My lord, in this matter, the CBI has already filed the written objections.
CBI.
Now, yes, my lord, I have challenged an order passed by the landed CBI trial judge. My lord, in this matter, CBI has already filed their affidavit in erosion. So matter may be kindly fixed for admission hearing.
Item number?
47.
Now 47 is fixed for what? Orders?
Orders, my lord.
Okay, 47 heard Mr.
B. Deka, my lord.
B. Deka, learned counsel for the petitioner, also heard Mr.
A Nath,
A. Nath, learned counsel appearing for CBI,
CBI.
who submits that this CBI has already, the respondent has already filed written objection against the petition filed by the written objection in this case, and this case may be fixed for admission hearing. Accordingly, let this matter be listed for admission hearing.
Admission, my lord, is it possible to fix a date on 23rd of January?
Date may be difficult after 2 weeks or after 1 week.
My lord,
Date registry will have to finalize.
No, my lord, I can take the date from the.
Oh, it will be difficult. Otherwise, we are putting burden on. Registry will fix the date after 2 weeks.
My lord, item 46, my lord, there is no stay. This is a criminal petition whereby by the impede over by
Which date up to 2 weeks?
DW was brought, my lord. And the next date before the learned court below is fixed on 11th, my lord. And I have taken I have taken on the notice was issued on 15/11 by this honorable court. I have taken steps on 15/11.
Whether it was served or not.
But my lord, the address has left from that place, my lord. So till next date, if they stay, other proceeding if it is not stayed, my petition will become infractuous. My legal right of.
No, you have to ensure service of notice.
Will not, but that is not.
Let it come up.
That is address here, left. Now I have to check whether the new address and all, because on one last occasion, London trial court has, without stay, has proceeded to directed me to produce the stay order from
Item number 46, let it come up on Monday. Monday.
May I
will be
please?
decided.
Item number 48, Lordship, there is stay, Lordship. We have filed an IA for stay vacation, Lordship. This matter may come up on Friday, Lordship. In criminal revision petition.
Not Friday, Monday.
All right, Lordship. Obliged.